Item number 1 to 8.
List is now called mention tomorrow. None appears. Just not come.
Mostly done in case of petitioners or petitioner, but some factual figures are required to be put down. Categorically stated in which paragraph from the top what is to be corrected, my lord. And my lord,
Have you given a copy?
yes, sir, I have served him a copy right now. And my lord, and
Let him see it. Let him see it. We are keeping it tomorrow. Yes, not today. Just go through it. We will also go through why so many corrections are required.
my lord, these are actually my lord, minor things. Somewhere it is 74,000. Inadvertently, it has gone down as 7,400. The case numbers, these are the minor things. And my lord, in some cases, where the pay fixation was initially done, 67,700, it has been written as 670. So minor, all are minor.
We'll see. We'll see. You also have a look at it. If it is minor, we'll.
One prayer, if I kindly say, my lord, in case of the first two writ petition, there was an overdrawal of certain amount. But I have also sought for a refund of the same.
No. That is not a to be mentioned matter. Yes. Not today. Send this. Send the files of your file. We'll keep it on Friday.
Friday, my lord. Grateful, my
A copy. So he has given a copy of the printout. If there are typographical errors, then it should be. Let us see. I have not seen also. You also go through.
But Friday to be mentioned.
Friday to mention.
Friday to be mentioned. Grateful, my lord.
Yeah.
Not today. Send it tomorrow.
আমি বলে দিচ্ছি বলে লিখে দাও না লিখে দাও
What is the problem?
Grateful, my lord.
Item number 9.
Lord, this is my appeal. Lord, we are supposed to carry out substitution. Lord, the death certificates have not been made over to us by the respondents.
Catch your breath. Don't wait. So last time also it was adjourned for 5
Yes, no, that is the point. They were supposed to make over the death certificates.
So we need some more time.
If Lordship kindly keeps it after 2 weeks, Lord, we'll try and do it.
The learned advocate. In attendance.
Item number 11.
None appears on behalf of
Well,
I appear for the petitioner that the petition that has been given to me at pages 77 to 80, it is not readable. It's like this. But I don't know whether in your lordship's brief, page 77 to 80 is legible or not. In my brief,
no, it is not legible.
we have to type it out.
Huh?
But I talked with the advocate record of the petitioner,
Yes.
that I will give a type copy to your lordship and a copy to me also, because this is not at all legible. How this has been filed, this is a recent order questioning which we approach the tribunal, and the impugned order first paragraph deals with this recent order. So if your lordship kindly give 1 week time, on Monday we will be coming with a fresh copy.
Mr.
Namodita Ranjan Bhattacharya.
13.
Should landed advocate for the petitioner is absent due to his illness, kindly make it not this week.
MS so and so, give your appearance.
Fourteen.
Petitioner Lordship, my senior, led by Mr. Fito Samin, he is engaged into Supreme Court matter. Lordship, kindly make it.
Recommendation is sought for.
Fifteen.
I am for the petitioner, my lord. Service, my lord.
Where is the advertisement?
My lord, in here there is no advertisement, my lord. I have appeared. The case,
You have appeared without an advertisement.
my lord, not without an
Where
advertisement.
is the advertisement? Show us.
My lord. The advertisement, my lord, is not.
Bring it on record. Let the learned advocate for the petitioner place on. Affidavit of service taken on record.
Sixteen.
Time for the petitioner.
Saying I will not show it. That's a good. Okay.
Proceed. Application 111 of the court, Lordship disposed by an order.
Hmm?
By my application, Lordship
By
was pleased to allow the application WPST 211 of 24.
yes.
Order is annexed here, my lord. The relevant page is 22, my lord.
Then why you have filed?
So pleased to set aside the order. But one, my lord, that he was in a part-time as well as the order passed by the in a way, my lord, not set aside. Subsequent to that, Lordship was pleased to direct the for consideration in the times of recommendation made by the dated 27 December 12. But the order speak itself as the enhancement of wages with effect from the order when Lordship was pleased to pass the order. Page 24, Lordship. Lordship set aside the order and direct the concerned authority to consider the recommendation dated 27 December 2012. But from the order, there is no highlights, madam.
What is it? Why? What do you want?
Lordship was pleased to pass an order directing the respondent of concern to consider the representation recommendation dated 27/12/2012.
Yes.
They have not considered it. They straightway,
They have not considered it.
no, madam. The straightway, my lord, passed an order on the basis of your order passed by a law.
So what have you filed?
Application, madam, for the appropriate order.
They dispose of matter.
In a dispose of matter.
This is all, madam.
Sorry, hard learned advocate for
Dismissal হলো তো? And what the
Dismissed. Can one dismissed?
17. Only two.
17 I am for the respondent.
17 kindly grants me a short passover, my lord. This is that matter where, my lord, we have stated that the Honorable Cat, while deciding the compassionate part, whether, my lord, the sister can be extended with the benefit of the circular of, my lord, that where, my lord, he stated that my lord, Central Administrative Tribunal, while, my lord, decide
Dependent,
yes,
sister,
dependent sister.
only if she is suffering from some
Yes,
mental or
yes.
physical.
Absolutely. And, my lord, the circular was quoted in a part. That was our case before your lordships.
So why do you want an adjournment?
My brief, my lord, I came running. Not an adjournment, my lord, if your lordship grants me a passover. My
Tomorrow we'll take it up, not today. This call tomorrow. Call this tomorrow.
Hmm? 18.
Suman Banerjee is appearing for the petitioner lordship. Due to personal difficulties, he has not come to court lordship. I'm praying for not to tell lordship.
This is that matter where the lordship had put certain questions with regard to the transfer was affected. I questioned the transfer order in the Jammu and Kashmir. I
Oh, that
obtained
one.
an interim order, and the interim order was subsequently just suddenly this was dismissed for default. Now vacated. The interim order was vacated. I preferred an appeal. Ultimately, the intra-court appeal the order was restored. That was remanded back. Be that as it may, ultimately the point the point boils down only that whether the service which I had rendered, between a particular from 13 April to say August, whether there is any evidence. I have filed an affidavit, indicating the evidence is there. Now, the second question comes from the bench that there are certain points which is a mixed question of fact and law. Whether this point was raised before the tribunal, if it was not raised, there was no occasion for me to raise this question. I relied on a judgment of the Supreme Court that the court can always take a subsequent event for the ends of justice. Now, the question is, here that I am armed with the Supreme Court judgment, which says under what circumstances the review is not maintainable in the before the tribunal. And the elaborate discussion, in the context of the rules, Administrative Tribunals Act and rules, the Supreme Court had elaborately discussed this point. I thought, that is my perception, that this would lend meaningful assistance to decide the lease. Now, the only point is this, that I'm entitled to raise this point because these points, the fact in issue, are not irrelevant. These are relevant, and this is not beyond the scope of the writ petition, and I am not enlarging the horizon of the writ petition. So, that is what. But today,
Your Lordship, learned senior advocate Ashok Kumar Chakraborty, learned ASG is appearing in this matter, Your Lordship, but he is down with flu, Your Lordship, as I have been
Next week,
informed.
11, subject to convenience.
He will come by 11th.
Your Lordship, I have been informed that this week, Your Lordship, he will not come to
But
court.
adjourned this too many times. We would like to finish. Last chance, we don't indicate normally. We don't know what will happen by 11. We are informed that Mr.
MD is extremely good.
All right.
Much obliged, Your Lordship.
Next
19.
matter, my lord. Here, my lord, 1998 March, my lord. In respect of the post of ticket collector, my lord, the railway
Post of
ticket collector, my lord, an advertisement and my lord, an advertisement was issued. Now, my lord, the vacancy occurred 1997. Ultimately, my lord, we could not find our place in the panel. We questioned the propriety of the selection process. Initially, interim order was granted. Then the tribunal, my lord, dismissed my writ petition, against which, my lord, I preferred the WPST, which was
Item number 19, too. Your Lordship, Shukumar Bhattacharya is appearing in this matter, Your Lordship. I have been informed that he is at his legs in another court.
ask him to come. Ask him to come. He's here. Ask him to come. We can proceed.
But he will not, he may not come. Another court. Pass it over. I will come back after at
Your
12.
Lordship, kindly.
बड़ी बताइए ना जो बताना है
Your Lordship, kindly make this not today, Your Lordship.
Why today attendance is also very thin. We don't know why.
Your Lordship, the train line is, Your Lordship, stuck.
Oh, that's why I was noticing. We were noticing since morning. The footfall is very little. Not today. Let it come tomorrow.
Weather puts him on a holiday.
For you. For you.
I enjoy it. But your lordship is not one.
Twenty. But I am for 20 and 21. This is the land usury scheme. Your Lordship has all points has covered.
See, nobody is there for the respondent. Just now we have been informed that there is some problem in the railway line. Probably we don't know what is the matter. Why? Since morning, repeatedly every case is being adjourned due to absence of one side or the other.
Then we are not today.
Can be done. Now, who is appearing for the other side in this case?
It a bit fine.
This is listed along with some other case.
Subrata Samanta. Santara.
No, this is listed along with some other case.
Yes.
There are two cases.
Okay. My learned friend, one case is.
You are appearing in both.
I am appearing for the 20. He is appearing 21.
20 and 21. Not today. Let us see whether they come.
Can be disposed of when.
Huh?
It can be disposed of when he will have.
Let us see. Let him be here, then we'll see whether it is disposed of. What is done.
I am for the petition.
Your Lordship, learned senior Sonajit Ghosh is appearing in this matter, Your Lordship. He's stuck, Your Lordship. He has not come to court yet, Your Lordship.
Some affidavit was to be filed.
Your Lordship,
He has filed evidence.
They had to file.
But, my lord, your lord can see the order passed from 30th May, 13th May. But the affidavit, my lord, they have not stated.
That is not the point. On 7th, we had adjourned it for filing the affidavit. Now they have filed it. Have you filed it?
Your Lordship, we don't have filed.
Why don't you place it on record?
Your Lordship, we have filed the affidavit.
You have already filed
Your Lordship,
in court.
The copy has been served upon.
Let us see. At least one step will be completed.
Lordship,
In terms of the last order,
Applying for the respondents.
Your Lordship, learned was making submissions in this matter, Your Lordship, and he is not well, Your Lordship. I'm praying that the matter could be taken up on next week.
Step, my lord. What is the next step? Or not?
1 week. We have granted 1 week.
1 week time.
Much obliged.
24.
What is the problem? Since morning, every
Your
case.
Lordship, Sonajit Ghosh,
Railway problem.
Your Lordship. He is stuck in Rishra, Your Lordship, at this time.
Not today.
Your Lordship, not today, Your Lordship.
24, 25.
25, 26, 26, 27, Your Lordship. These are land losers matters, Your Lordship.
Land loser matters. Your lord covered by your.
Who is going to appear?
Your Lordship, Mr. Sonajit Ghosh, learned senior, is appearing in this matter.
See, we are keeping it after 1 week. Why? Yesterday, in one matter, there was a modification or some correction was being done in the order. The learned Mr. Mr. D.N. Ray informed us that some matters have been taken to the apex court. Recent orders. We don't know. He has not given us the details. You please ask him to tell us the details, which matters he has filed the SL.
But instead of 1 week, my learned junior will not be there. Lord makes it 2 weeks.
True.
Be on the safe side.
As jointly prayed, list up. Till now, we were following whatever is being done.
Yes.
But if they have proceeded, then
All the matters had gone to the Supreme Court and we had shown your lordships the order. But then they are saying something new has been filed.
let us see.
24, 25, 26, 27. Right? So,
You are appearing in all. Please ask someone to give an appearance.
yes, but I'm giving. 27, 28.
Same.
Up to 29. 24 to 29.
24 to 29.
Your Lordship, I am only till 27, 24, 25, 26, 27.
Anyway, lordship has to adjourn it because of that. 24 থেকে 29. I'm grateful. 2
For
weeks.
24, we will already jointly prayed 2 weeks. That's all. You please intimate that we want to know what is the detail of the matters which have been taken up, because we are relying on certain orders passed earlier. We don't know whether those orders have been taken up or which matter has gone to the Supreme Court. So we should know before we proceed further. You can exchange the information so that we are informed. We are informed on the next date.
My God, learned advocate is not in the Supreme Court already. Because he was dealing with all these matters. I'm grateful.
Your Lordship, in item number 23, Your Lordship has granted 1 week time, Your Lordship.
2 weeks. All the matters 2 weeks because of my learned.
No, in item number 23, where I appeared for the petitioner. Your Lordship, learned advocate for respondent is here.
Not be available next week. That is why. After 18th.
Huh, 2 weeks.
কি করে হবে 28 হবে তো
30.
You want to proceed? Overtime allowance has been allowed. And they are which post? Coach attendants. This is already decided. We have passed orders in some writ petitions. No, where is that order? Where is the respondent? This order is of which date?
14th day of March.
We have relied on some. They are claiming parity with the with some other employees. Let the respondent be here, not today. Take it back, you give it tomorrow.
Everyone, please, my lord, I am for respondent numbers 2 and 3.
Doesn't matter today. In every case, somebody or the other is not appearing.
Lord, I think the inclement weather is sometimes an
Probably.
excuse for petitioners not to turn up.
No, in many cases, respondent is not there. In some cases, petitioner is not there. The weather has been more or less like this every day. What is so unique about today? You're for the Union of India.
No, my lord, my friend is for Union of India. I am for 2 and 3, National Small Industries. Lordship had taken this matter up on the first occasion and expressed your lordship's minds that there is no provision for compassionate appointment. There is no scheme. They are seeking compassionate appointment without a scheme, my lord.
None appears for the petitioner.
Thirty-two.
None appears for either of the parties.
Thirty-three.
For my lord, in this matter, for media matter.
Lordship, in item number 34, I beg to appear for the petitioner. In item number 36.
You are appearing 34.
My lord, appearing in 34. My lord, I was virtually present, but I was not connected to the meeting. In 32 and 34. Lordship, in item number 34, I beg to appear for the petitioner. In item number 30. My lord, in the item number 34, there was a direction upon the respondents to submit affidavit. And my lord has noted as a matter of last indulgence.
We'll keep this along with the other matters which we have adjourned for 2 weeks. This is also land loser matter.
My lord, kindly give us a short date, my lord.
No, we'll keep it with the other matters on the same date. The affidavit has not been filed in terms of the last order.
Grateful, your lordships.
In all the land loser matters, we'll keep it after 2 weeks now.
Grateful, your lordships.
35.
35. I appeared.
You are petitioner.
The matter. It was last adjourned, my lord.
Because that review was pending. Now it is over.
Now it is over, my lord.
So we can proceed on merit.
Merit, my lord. And we have to start upon the respondents. Lordship, kindly pass a direction to start copy upon the respondent, my lord, and fix a date. This is for recovery of excess payment made to the my lord. He has retired.
Let us see on merits what is the issue. He has approached the tribunal for what relief? Challenging an order of 15/7/21.
Recovery of my lord. Excess payment was made.
Where is that 15/7/21 order? So the tribunal has allowed his claim.
Yes.
Let us see what is the order.
The impugned order is on 11th August.
No, 15/7/21 is the communication which was challenged by the applicant before the tribunal.
And when the final order was passed on 11th August, your lordship kindly peruse, my lord, the impugned order. What the notification by which, my lord, during the COVID period, what is to be done?
So there is a Order of the Railway Board on 3/9/2020. Where is that?
It's one that P2, page 21. September 2020 notification. How and when the amount is to be deducted.
So he is covered by which situation?
Yes, situation, my lord, that is, my lord, serial number, page 2, my lord, page 53, serial number 7, my lord, your lordship, kindly 7 and 8. An employee who was in headquarters but did not turn up for duty on being called absent, the period and pay may be decided as per normal rules. And 8, my lord, an employee has left the headquarters without permission and later informed he is not able to reach back to the office due to lockdown.
So he is covered by 7 or 8?
Covered by 7.
But your letter which has been quoted, the letter of 15/7/21, it does not say that he is covered by 7. At the time, what it says is he was absent for the period at the time of lockdown. There is no allegation that he was called and he did not come.
That is not mentioned.
It's not mentioned.
And my lord, the judgment of the apex court relied on, that is all are prior to, my lord, the present notification. And that is not considered in the judgment relied on by the tribunal itself. And may I serve and come back?
What is the point? What is the point? If there is a
The
point,
notification is applicable, though, my lord, that is not mentioned. Your lordship is.
there is no mention that he was called, he did not come. Secondly, this is only an interim measure. We don't know what final decision board has taken. This is not the final order. This is an interim order. You see the second paragraph at page 21.
Page 21.
Therefore, it has been decided to regularize absence during COVID-19 epidemic as per following measures for only those situations which have not been covered under the above mentioned DOPT letter dated so and so as an interim relief till further clarification. We don't know. There is nothing before the tribunal. This was an interim measure. Even this 7 that you have relied upon in the tribunal, that does not appear to be applicable from your letter of 15/7/21. And why you have waited for him to retire when you wanted to make the recovery? You could have done it during his service. And from gratuity, you are making the recovery.
And may I come back with instruction, and your lordship kindly fix a date, my lord, serve notice upon the respondent. I come back with that particular instruction.
Notice may not be required. If you want to take any instruction, you can take it, but we don't think he is required. We are prima facie, we are not, we are not inclined to.
As your lordship, we shall not serve, because, my lord, if your lordship satisfied, my lord, if one served notice, my lord, that is completely, my lord, your lordship can finally dispose of the matter. That is why I am.
But somebody is already appearing for the respondent. Why notice has to be served?
In that event, your lordship kindly fix, my lord, if
You
notice.
please inform him. His name is appearing, Mr. Sheikh Siddiq Rahman,
I shall do.
assisted by Mr. Sarvesh Chandra Srivastava.
I shall.
You inform, none appears on behalf of the respondents.
Lordship, I appear for the petitioner in this matter. This matter is that matter, my lord. Your lordship heard us. We challenged. We made a
Opposition is filed.
We have filed our opposition long time back. State
Yes,
has
the
proceeded-
Public Service Commission has filed their opposition. We have filed our reply on that. The state, after a lot of persuasion or on our behalf, they have served us with a copy of the opposition yesterday in the second half, my lord.
You are for?
Officer commission.
I need to file the reply against the state.
Who is
Secretary
appearing for the state?
and Somnath Noshkar, my lord.
Mr. Tapan Mukherjee is appearing. Where is he? Has it been filed, the opposition of the state?
I have also received a copy of this opposition filed by the state.
And
it has been affirmed on 1st July.
Very shockingly, my lord, the opposition has been affirmed on 1st July and they are serving yesterday to me. Subject to your lordship's correction, my lord, kindly fix it next Wednesday.
No, let him be here. Let us at least take it on record. Unless it is on record, what reply you will file?
I give him.
Tell him we are just adjourning it, not today. It will come tomorrow.
Yes.
Just call it tomorrow.
I appear for this applicant respondent.
I have almost concluded my submissions. Well, it is that matter that a criminal charge sheet was issued, my lord, under section 8C of the NDPS Act. Now, that criminal case was ultimately, my lord, they were acquitted, my lord, from the criminal case. A disciplinary proceeding was also initiated.
they filed the charge sheet before the West Bengal Administrative Tribunal. The tribunal, my lord, is to observe that in view of the acquittal in the criminal case, this charge sheet is liable to be quashed. Challenging this, my lord, we filed this writ petition, my lord.
There are some more writ petitions.
There are 4 writ petitions, identical issue, my lord. 4 different constables, my lord. Same point of law is in.
They were all members of the same rating team.
Yes.
So what is the date of the charge memo?
My lord, the charge memo date is 23rd of September 2022. To be find it at page 133. This is 23rd of September.
136.
133. At the relevant point of time, the petitioner was in judicial custody at Krishnanagar. Now, the department, my lord, tried to serve them, my lord, to the superintendent of the correctional home. Now, the applicant refused to accept the first charge sheet. Then a supplementary charge sheet was issued, my lord. That is dated 3rd of November 2022. That your lordship will find at page 140. The tribunal, my lord, I'm sorry.
So this became an additional charge.
This became the additional charge. My lord, the tribunal, with the best of respect, has not referred to the second charge sheet. The first charge sheet was quashed on the ground that since they were acquitted in the criminal case, this first charge sheet is liable to be quashed. But so far the second charge sheet is concerned, my lord, there is not a single whisper.
Yes.
Now, my lord, I have, my lord, pointed out, my lord, 4 legal points, my lord, and in support of those 4 legal points, my lord, my lord, submitted, my lord, 4 judgments. My lord, the first legal submission is, my lord, that the standard of proof, my lord, required in a criminal case and in a disciplinary proceeding are different. Your lordship knows, my lord, in a criminal case, the standard of proof is conclusive proof. And in a case of disciplinary proceeding, my lord, a charge can be proved on the basis of preponderance of probability.
So acquittal is not relevant. And second point was?
The second point is, my lord, that the additional charge sheet dated 3rd November 2022 was an independent and separate charge. The second charge sheet does not have any connection with that criminal case. It is a clear case of, my lord, insubordination. Therefore, my lord, and it will come within the meaning of misconduct. Therefore, my lord, this issue has not been, my lord, decided by the tribunal.
Yes, third.
Third is, my lord, a charge sheet, my lord, does not give rise to any cause of action. My lord, it is the inherent power of the employer, my lord, to issue a charge sheet in accordance with the service rules and, my lord, decide the charge upon giving opportunity to the employee.
Yes.
My lord, my fourth submission is, my
So
lord,
it should not have been interfered with, only after the proceeding. Yes.
my lord, my fourth submission is, my lord, a charge sheet, my lord, as your lordship time and again and the Honorable Apex Court, my lord, has decided, my lord, can be challenged mainly on three grounds. The first ground is, my lord, that if it is, my lord, issued without jurisdiction, the person who has issued this, if he does not have jurisdiction, then it can be challenged.
Yes.
My lord, the second is, my lord, that if there is any statutory violation while issuing that charge sheet, suppose there is a provision for preliminary inquiry, if that is not adhered to, then, my lord, that can be challenged. If there is any statutory violation, a charge sheet can be challenged.
Yes.
My lord, the third ground is, my lord, there are two sub grounds. First is, my lord, if there is any malafide on the part of the employer, or the charge is absolutely vague. Suppose, my lord, the charge does not make any sense, then one can challenge the charge sheet. That one, a reasonable one, my lord, failed to understand that what is the charge.
Yes.
My lord, here, this is not the case which has been made out by the petitioner. None of these, my lord, grounds, my lord, has been satisfied, my lord.
So both the charge memos were challenged.
Both the charge sheet was quashed, my lord. It was challenged and quashed. But so for the second charge sheet, my lord, there is no whisper, no submission, nothing.
You filed a reply before the tribunal.
No,
You must have.
no reply was filed.
No reply was filed.
Reply was filed. There wasn't direct.
It was heard out at length without the affidavits, your lordship. Affidavits have been exchanged before your lordship here in this court.
Here they have already filed. So here he is the writ petitioner.
I'm the writ petitioner statement. Yes. Now, I have, my lord, placed before your lordship some judgments, my lord.
In the charge memo, second charge memo.
My lord. Document.
So not responding to a charge memo is an offense, misconduct.
It is a misconduct, my lord, with deepest of respect, to the extent, my lord, when my lord, an higher authority, my lord, is trying to serve a letter, any administrative letter, my lord, upon the employee, my lord, refusal itself is a misconduct. One cannot refuse, my lord, an official document. Suppose, my lord, your lordship, it may be in connection with leave, maybe in connection with transfer, maybe in connection with any administrative job. One cannot say, I will not accept this letter.
That's why we are asking you. That's not the circumstance here. This is non-service of a charge memo. This is not an administrative order which requires compliance,
My lord, it was
and non-compliance of which will entail a act of insubordination. If one does not respond to a charge memo, you proceed.
my lord,
Ex parte, it is done every day.
my lord, kindly.
It is not a new thing that
Consequences thereof. My lord, kindly see the consequences.
that's not the point. The point is, does it constitute a misconduct for which a charge memo has been issued?
My lord,
Non-service of a charge memo itself will constitute a misconduct. So in every case where the party does not appear, an additional charge should be added.
my lord, a charge
Yet
memo.
to see such a
The deepest of respect, my lord. Maybe
Yeah.
your lordship kindly correct me if I am wrong. My lord, a charge memo is issued, my lord, following a statutory rule.
That's not a command in the discharge of official duties. That is not a direction by a superior authority. That is an opportunity given to a person against whom allegations have been leveled. If he chooses not to respond, how it can be a insubordination?
Probably, my lord, he didn't know what document he was going to be served. My lord,
No, because look what your charge memo says. Therefore, we are asking.
now
You
Western
see
is,
what
my
it
lord,
says, what you have relied upon. At the first attempt, you say that they have refused to accept the notice and provide any written reasons for such refusal. This is communicated by your correctional home
Yes.
on 24/9/22.
Yes.
Then on the second occasion, you say we have sent it to his home. He has refused to take delivery of the respective notice.
Yes.
And the third is, there are 3 attempts which you say you have made. We don't know.
Yes.
The final attempt was made by posting it on his house. So how do you know he doesn't know? And even if he doesn't know, that will not change the fact of what you have sent. You know what you have sent.
Now, my lord,
Whether
these
he
are
knows or not, that is not.
the proceeding, my lord. If
Whether it is, therefore we are asking you, non-service of a charge memo, show us any judgment that non-service of a charge memo or non-acceptance of a charge memo would amount to a misconduct.
my lord, the service rule, my lord, any service rule.
Let
your
us
lord-
see the service rule. It is conducted under which proceedings? Where is the procedure for conduct of the disciplinary proceedings? Yes.
I have handed over.
Yes, we have it. So charge memo is issued under which provision?
Kindly consider Rule 10 of this West Bengal Services Classification Control Appeal Rules 1971. Let me place this one. No order imposing any of the penalties provided in rule except after an inquiry held in the matter.
There is no file. There is no file. In my file, there is no file. At the bottom.
Shall I hand over?
You have an extra copy?
Yes, yes.
We have one.
দুটো কপি আছে মানে this is মানে West Bengal Services Classification Control and Appeal Rules 1971.
Yes.
Yes. Well, kindly consider Rule 10.
10.
Yes. Well, Rule 10 deals with procedure for imposing penalties. Well, may I place this? No order imposing any of the penalties specified in Rule 8 shall be made except after an inquiry held in a manner provided in this rule. The disciplinary authority shall draw up cause to be drawn up, the substance of imputations of misconduct or misbehavior into definite and distinct articles of charge, etc. Kindly consider 3. The disciplinary authority shall deliver or cause to be delivered to the government servant a copy of the articles of charge and the statement of imputation of misconduct or misbehavior prepared under clause 2 of subrule 2, and shall require the government servant to submit to the inquiry authority with such time as may be specified a written statement of his defense and to state whether he desires to be heard in person. Therefore, my lord, there are two things in 10 subrule 3. First, my lord, either my lord personally hand over or ensure that someone else deliver it, my lord. Kindly see the first line. The disciplinary authority shall deliver or cause to be delivered to the government servant. And then, my lord, the third line, and shall require the government servant to submit to the inquiry authority with such time as may be specified a written statement. Therefore, my lord, the disciplinary authority, my lord, must ask the delinquent employee to give a written reply to the EO, the inquiry officer, within a specified time. Therefore, my lord, this has been violated, my lord. One cannot say, I will not accept it. He may say that I will not file any reply. Subject to your lordship's kind correction, my lord. The first line of sub-rule 3 says, my lord, the disciplinary authority either personally deliver it, or my lord, he can, my lord, hand it over or ensure someone, my lord, for delivery of that charge sheet.
Yes.
No, my lord, therefore, my lord, this rule 10(3), my lord, provide, my lord, two things. First is, my lord, the disciplinary authority, my lord, either personally hand over or, my lord, ensure that someone else, my lord, delivers it to the delinquent employee. The second thing, my lord, your lordship will find that and shall require, third line, government servant to submit to the inquiring authority with such time as may be specified a written statement of his defense and to state whether he desires to be heard in person. Therefore, my lord, the disciplinary authority must ask the delinquent employee, my lord, to give a written reply to the inquiry officer or, my lord, the disciplinary authority within a specified time. Now, your lordship will find from page 141, the second charge sheet, my lord, part of that second charge sheet, that this was indicated, my lord. This was indicated, and thereafter, my lord, the charge was framed. Now, one of my argument was on the last occasion that both these proceeding, although it's a single disciplinary proceeding,
Is there any list of misconduct given in this?
Yes, yes, what you will find from the misconduct, my lord, in so many words. Rule 8 deals with penalties, but my lord, in this rule, my lord, misconduct in so many words has not been
defined. Penalties are in which rule? 9.
My lord, 8, my lord.
8.
8 under part 5. But I cited 3 judgments, my lord, on this.
You have yet to read the entire provision. We have seen the judgments, we remember what you argued. We did not go through the provision that day. It's a revelation. Come to 9. First note under 9.
Yes, my lord, in all cases of fraud, embezzlement, or similar offences, the disciplinary authority shall take steps to institute departmental proceeding against all the delinquents and conduct them with strict adherence to the rules up to the point at which prosecution of any of the delinquents begins. At that stage, it must be specifically considered whether further conduct of the departmental proceeding against any of the remaining delinquents is practicable, and if so, it shall continue as far as possible, which will not, as a rule, include finding and sentence. If the accused is convicted, the departmental proceeding.
That is the first option. If he is convicted.
The accused is convicted, the departmental proceeding against him shall be resumed and formally completed either by dismissing or removing the person from the government service or by reducing him in the rank on the ground of his conviction.
Now second option.
Yes. If the accused is not
convicted, then
the departmental proceeding
should be dropped.
Yes,
That is the mandate of the rule unless that second part is complied with. Recording of an opinion that there is sufficient grounds which still discloses. Where is that?
Unless the authority competent to disciplinary action is of the opinion that the facts of the
Where is that opinion?
grounds for taking. Now,
Where is that opinion?
I tell your lordship,
Any such opinion has been recorded after issuance of the initial charge memo, not there. Now you come to another provision. 10(6).
if the government servant who has not admitted any of the article of charge in his written statement of defense appears before the inquiring authority, such authority shall ask him whether he is guilty or has any defense to make, and if he pleads guilty to any of the articles of charge, the inquiring authority shall record the plea, sign the record, and obtain the signature of the government servant thereon. The inquiring authority shall return a finding of guilt in respect of those articles of charge to which the government servant pleads guilty. The inquiry authority shall, if the government servant fails to appear within the
Now comes this, which you are saying constitutes the second charge.
Yes.
What is required to be done if he fails to appear? Respond.
Now,
Just read. If he fails to appear, if he fails to
within the
plead,
specified time or refuses or omits to plead or claims to be tried, require
nothing, he does nothing as has been done in the present case.
Yes. Or his representative produce
Then he
the-
has to proceed in this way. Where's the question of it constituting a charge?
reached to that level, my lord. Has not reached to that stage.
And the same kind of a provision is there in 14 also. So at the next stage also, he may or may not participate. It's not any kind of an administrative direction or command that he has to comply.
We have not, my lord, reached to that extent, my lord. Only the disciplinary proceeding was engaged. Now, the disciplinary proceeding thereafter, my lord, issued a letter directing him to appear before the inquiry.
Where is that letter
Yes, my
directing?
lord. That letter is at page 150. 150, my lord. Kindly consider, this is very relevant, my lord. This is the first letter subject to, my lord, correction, my lord, page 150 is the letter, my lord.
There is a direction. Just show the word you are directed.
My lord, you are requested, last third line, my lord.
Yes.
You are requested to
See, that's why we said a charge memo is not a direction by an authority to the subordinate. A charge memo is an opportunity under the principle of natural justice to come and see the allegation and make your defense if you want. It's an option, it's not a direction.
My lord, do not receive the charge sheet, my lord. The inquiry cannot be proceeded with. I cannot.
Oh, no. That is why the rule says if you don't appear, they are to proceed.
My lord, appearance before the inquiry is one thing. This is
Yes.
summoning someone. But my lord,
And what is a refusal to accept?
My lord, the refusal to
What
accept.
is the consequence of a refusal to accept?
My lord, subject to correction, my lord, I will say this is certainly, my lord, come within the purview of a misconduct.
No. What is the concept of a refusal to accept means valid service.
Valid service. Deemed service.
It is established.
Service.
It is established.
Yes. That is
In your repeated correspondence, you have said they have reported that he has refused. Who stopped you?
Service.
So who stopped you?
Now, my lord, this 151, they said they asked for some time and
Therefore, consciously they don't direct. That's why we asked you, where is it? Show us. It can't be a direction. A charge memo is always only an opportunity that, look, this allegation we have found or we are making against you. We allow you to come and participate. You can look at the evidence. If you want, copies can be given. If you request for something which is immaterial, we will say we will not give it to you for this and this reason. We will proceed. The presenting officer will present the evidence. You will have your opportunity, and inquiry officer will submit a report after giving you a copy. Second stage, your opportunity to file a representation, and then the disciplinary authority decides, concluding the proceeding. You may avail statutory remedy, you may not, you may accept the finding, you may be acquitted. It's not a direction at any point of time. Therefore, we asked you whether misconduct, is there any such provision regarding insubordination in any rule?
There is one rule that
We would like to consider, therefore we are asking you.
That is, my lord, very general in nature. There is one rule is called West Bengal Services Duties, Rights and Obligation of the Government Employees 1980. But this is very general in nature.
But it applies to all, including this petitioner.
Yes. To all government, state of services under this government of West Bengal. My lord, your lordship will find three duties, my lord. There are three things: duties, rights, and obligations. My lord, there are several duties which have been prescribed, then rights have been indicated, and then obligation, my lord, at the end of first page.
So this connects with section 8 at the bottom of second page. Any violation or infringement of these rules shall be deemed as a good and sufficient reason within the meaning of Rule 8 of the classification of.
Yes, ma'am. But my lord, misconduct as a whole, that has not been defined.
So there is no provision that if a command or a direction is given in one service rule, we have seen it at some place, and you don't agree, then if you don't intend to comply, then you are required to write back.
My lord, in Railway Protection Force,
There they have it.
RPF
Somewhere.
Act, Act and Rules, my lord, 1987. There, my lord, there is a provision that if a commanding officer, my lord, gives a direction to its subordinate officers, my lord, it has to be adhered to. There is such provision. There may be other provisions also in other service rules, but in RPF rules, my lord, there is a provision.
Here there is no such provision. It is nonetheless insubordination will be a misconduct, even if there is no provision. So the issue remains whether this charge memo is a direction by a subordinate, by a superior to a subordinate, or it is an opportunity given to participate in a proceeding.
My lord, this,
And having regard to the provision in your rules, which also contemplates how to proceed. Once it is served, they refuse to accept, then you are just, what is supposed to be done is already prescribed there.
but this page 133 was issued, the first charge sheet was issued by the Excise Commissioner. Now,
133.
First charge sheet, my lord, this is dated September 2022.
This is the first one. Second one is of 3rd November.
Yes, page 140.
Yes, we have seen it.
Yes, my lord, that was also issued by the Excise Commissioner, the highest officer of the department. Now, my lord, I will once again, my lord,
And the petitioner in all the cases are?
Constable, my lord.
So he is the disciplinary authority for constables. All are constables or?
All are constables. All these 4 writ petitions
Four.
all are constables. My lord, this, if your lordship kindly consider once, my lord, rule 10(3) of the CCA rules, my lord, may I just indicate one thing?
Yes, you have read it. We
Yes,
saw
my lord,
what
my
you
lord,
are
the first sentence.
Yes,
is
shall.
The disciplinary authority shall deal with
Yes,
cause.
you
Therefore,
have.
this is an obligation on the part of the disciplinary authority. It's a mandatory provision.
Yes.
And the second part is also, my lord, a mandatory provision that and shall require the government servant to submit to the inquiry authority
Yes.
with such time as may be specified a written statement of his
Yes.
defense.
So that opportunity he has to give. It is a mandate
Yes.
that you shall do it. You give a time within which he can come and
Can come and, my lord, give a
respond
reply.
if he wants.
Yes. Therefore, both these provisions are mandatory in nature. And, my lord, I think, my lord, my respectful submission is, my lord, the prosecution, my lord, when tried to serve a copy of the charge sheet, which was refused by the petitioner, my lord, this comes, my lord, within the purview of this misconduct, my lord. These are my submissions. My lord, may I indicate?
You have given us the judgments.
Yes, I have, my lord, handed over. My lord, I can give a compilation also if you like.
Give us one page, that will be good.
Lordship, I done it. Relied on 4 grounds. I shall deal with the first charge sheet. Your Lordship, the first charge sheet. Your Lordship may kindly come to page 130.
Yes.
133. Your Lordship, the question of the annex, Your Lordship, from 135. The article of charge and statement of imputation. The article of charge and the statement of imputations are identical, Your Lordship. Though the articles of charge is not legible, that will kindly come to page 136. Is that said Moram Sheikh Constable was consciously present in the raid and played a conscious role in collusion in the matter of illicit possession, transportation, and disposal of commercial quantity of narcotic drugs. In the wake of
Yes, we have seen it. Neither the drug is specified, neither the quantity is.
the only reliance that has been placed on is the NDPS case. Your Lordship will also kindly come to page 137. The only document that has been relied on by in the charge sheet is the the charge sheet that has been submitted before the NDPS case. And if your Lordship, the order passed by the NDPS court is considered, your Lordship, it is clear that the authorities have failed to prove any case at all, your Lordship. They have failed to make out any case whatsoever, and the petition, the respondents herein have been acquitted. If I may say, honorably acquitted, your Lordship. Your Lordship, in this circumstances.
No, in 138, they have relied upon a charge sheet.
Yes, your Lordship. As you will kindly see the document they are relying upon, list of documents, copy of the charge sheet submitted.
Page 136, 138.
137, your Lordship, sorry. Extremely sorry. Copy
Yes.
of the charge sheet submitted by the additional commissioner such and such in NDPS case number 136 of 70. Your Lordship, the order passed by the NDPS court order, the relevant portion is at page 132, where it clearly indicates that the accused had faced trial and are found not guilty of commission of offense punishable under the sections under such and such, and as such they are acquitted from this case. The observations made in the order, page 127, also indicates, your Lordship.
Only the charge sheet is the only evidence
Yes,
enclosed with the charge.
that is the only document they have relied on. The article of charges, the imputation of charges also rely on only the case, your Lordship. So it cannot be said by the petitioner herein that the charges are similar, but they are only relying on the charges that was placed before the NDPS case, or they are relying only solely on the NDPS case.
So where is the judgment?
Your Lordship, the judgment is.
No, the judgment that whether based on an FIR and charge sheet.
Your Lordship, the judgment starts from 78 and the order portion is at page 132. Your Lordship, the observations would clearly say there is no iota of evidence before the court. There is no corroborating evidence. The authorities have failed to produce any evidence, no evidence at all. And the order indicates that they have faced trial and is found not guilty of commission of the offense. In this situation, your Lordship, read with clause, the note in clause 9 of the regulation.
Which we had just read.
I was surprised. You could indicate.
No, that one only or something else here.
That one. And read with the judgment of 2024 1 SCC 175. Your Lordship Ramla. There's a compilation.
Relying on Roop Singh Negi case. Is it referring to Roop Singh Negi's case?
Ramlal versus State of Rajasthan. There are 5 judgments I'm relying on. Your Lordship, all are on the similar ground. But the latest is of 2024 1 SCC 175, paragraph 29 and 30. At page 50, your Lordship, of the compilation. And come to page 51, paragraph 30.
Paragraph.
Paragraph 2930, your lordship. But paragraph 30, saying the disciplinary proceeding and the orders passed thereon cannot be allowed to stand. The charges were not just similar, but identical, and the evidence, witness, and circumstances were all same. This is a case where, in exercise of our discretion, we quash the order passed by the disciplinary authority.
Relying on GM tank.
Yes, your lordship. Bishop, the other judgments of 2019-10 SEC 367 also has a similar judgment. Page 36, 2019-10 SEC 367.
Which paragraph you are relying?
Lordship, paragraph 11 is the relevant paragraph. Page 41 of the compilation.
Yes.
2015 2 SC 365, paras 21 and 26. Page 35. All on the same point, your lordship. Lordship, in these cases, the charges were identical. Here in this case, the only reliance was on the case. On the NDPS case, the charge sheet relied on the NDPS case, where the respondents herein have been acquitted. After consideration of all the evidence placed before the court. Your lordship, clause 9 also clearly says, note 1.
Yes.
That if the accused is not convicted, the departmental proceeding against him should be dropped unless the authority competent to take disciplinary action in the opinion that the fact of the case disclose adequate ground for taking departmental action against him. Your Lordship, there is no such observation in the charge sheet or in any communication whatsoever.
No, there is no exercise after dropping of the case.
No, Your Lordship.
That charge memo which they had framed, they have been trying the same charge to serve the same charge memo, which they say we have done thrice. Once while he was in the correctional home, once after acquittal, and once at his home they have pasted it.
Thereafter, we have
Not their
received,
case.
we have made representations, we have challenged, we have made representations that we have been acquitted.
You have made a representation
We had written for
in response to the charge memo.
we had written to the authorities that we have been acquitted after being acquitted. Released, we had made representations indicating that we should be.
Show us what is the date.
Yes, Your Lordship, I shall. And
Prior to 3/11/22 or after?
Your Lordship will kindly come to page 144. After receipt of both the memos, Your Lordship. We had replied.
So this is after the
Yes, Your Lordship.
second charge.
After. In that event, the submission that the standard of proof of criminal proceeding and disciplinary proceeding in the instant case does not arise. So in the event the charges are, sorry.
Yes.
The charges, the submission made by my learned senior friend, that standard of proof is different, do not arise in the instant case, relying on this judgment and the fact that the charges were not only identical, but the sole reliance was placed only on the NDPS case. And the second submission which was made, that the charge can only be challenged on 3 grounds, out of which one is vague. Your Lordship, the memorandum of article, the statement of imputation would be clear that there is no indication of any sort at all, that what was the quantity, what was the disposal, no details have been granted. The charge sheet is absolutely vague. So the submission made on this ground, that the charge sheet could not be challenged because none of these 3 grounds had been made out, does not also stand, because the charge sheet is absolutely vague, and this point had been taken not only before the tribunal but also before this learned court, Your Lordship. Secondly, Your Lordship, the second charge sheet, the submission was made that it is an independent charge sheet.
What is the date of acquittal?
Date of acquittal is, Your Lordship, 30th September 2022.
20?
And the first charge sheet was issued only on 23rd September 2022.
And the allegation pertains to which date?
Your Lordship, the allegation for?
Pertains to which date?
Pertains to an incident of, Your Lordship, 2018. Of an incident of 2018. The alleged seizure or the date was on 5th September 2017.
17?
17. 5th September 2017 was the alleged date. I was put on suspension since 2018. And thereafter.
So just a week before the acquittal, they have issued the charge.
Yes, Your Lordship. Your Lordship, secondly, finally rather, Your Lordship will kindly see page 140, which they refer to as a fresh charge sheet. Clearly indicates addendum to the order of departmental inquiry. Starts as addendum to the order of departmental inquiry initiated. Lordship, this is a my respectful submission will be, this is a continuation of the earlier charge sheet, Your Lordship, first, and with the main charge sheet.
The nomenclature hardly matters. They have brought additional charges, whether by way of an addendum or by way.
And secondly, Your Lordship, I shall place reliance on clause 10.6. Your Lordship, I shall place 10.3. first, your lordship, as relied by my learned senior friend, it says, and shall require the government employee to submit to the inquiry authority, which needs to be read with clause 10(6), which says the inquiry authority shall, if the government employee fails to appear within the specified time or refuses or omits to plead or claim to be tried required, they may proceed. Your Worship, the second charge sheet on the ground of non-acceptance of initial charge sheet does not arise. Your Worship, the West Bengal Service Duties, Rights and Obligations of Government Employees rules also indicates the duties and obligation where there is no mention of acceptance of a charge sheet, your lordship. I shall submit
Yes,
that.
we have seen that.
Yes.
That's not their case. We just wanted to know whether there is any such to
There is
clarify.
no such indication, your lordship. 10(6) is clear. The
Irrespective,
refusal.
irrespective of the fact that it is there or not there, any insubordination will constitute a misconduct.
But refusal of accepting a charge sheet cannot be termed as an insubordination.
Insubordination.
Very short. That my learned friend, Malat, cited 2024 1 SCC 175 Ramlal's case. This case, your lordship will find that a criminal case and a disciplinary proceeding was initiated against this Ramlal. The charge was, Malat, he altered his date of birth. Now, the inquiry officer in that disciplinary proceeding found him guilty. Thereafter, my lord, the disciplinary authority dismissed him from service. My lord, thereafter, the trial court also convicted him. However, the appellate court acquitted him. Now, my lord, the issue which was claimed by the apex court is at page 8, para 8, my lord. Kindly consider 8.2, my lord, at page 178 of this chart. Internal page 4. Sorry, my lord, page 45 of the compiled. My lord, kindly consider in the middle, my lord, paragraph 8, questions for consideration. The following two questions arise for consideration: whether the dismissal of the appellant from service pursuant to the departmental inquiry was justified. This is not relevant. Then 8.2, on the facts of the case, what is the effect of the acquittal ordered by the appellate judge in the criminal trial on the order of dismissal passed in the departmental inquiry? That means, my lord, the departmental inquiry was allowed to continue.
Therefore, not at the charge memo stage, which you had submitted.
Exactly, my lord. And the Honorable Apex Court, my lord, was pleased to observe that in para 30, which my learned friend has placed, my lord, the last page. Paragraph 30, we are additionally satisfied that in the teeth of the finding of the appellate judge, the disciplinary proceeding and the orders passed thereon cannot be allowed to stand. The charges were not just similar but identical, and the evidence, witnesses and circumstances were all the same. Now, my lord, my respectful submission before your lordship is that the Supreme Court, my lord, did not, my lord, restrain the disciplinary authority, or the High Court, my lord, restrain the disciplinary authority to proceed with the delinquent employee. The disciplinary proceeding was allowed to continue, the criminal proceeding was allowed to continue, and thereafter, my lord, the Honorable Apex Court, my lord, considered the evidence, witness, circumstances vis-a-vis the evidence, witness, circumstances in the criminal case, and then, my lord, came to this conclusion, my lord. My lord, I'm sorry.
Yes.
My lord, in the second judgment, my lord, 2019 10 SCC 367, paragraph 11, my learned friend placed, my lord, your lordship will find from paragraph 11. But there also, the disciplinary proceeding was allowed to continue. Well, kindly consider this. Here, reliance was placed on such and such a judgment of this court in GM Tank, whereby the writ petition filed by respondent was allowed. In the said case, the delinquent officer was charged for an offence punishable under such and such. He was honorably acquitted by the criminal court as the prosecution failed to prove the charge. Thereafter, the departmental inquiry was conducted and he was dismissed from service, my lord. The disciplinary proceeding was again allowed to continue, my lord. Now, the only thing is, my lord, my last submission is, my lord, my learned friend has placed page 137 of the writ petition.
Yes.
That means, my lord, that the prosecution, my lord, referred to only the charge sheet.
Yes, and two witnesses are also.
Yes, my lord, my respectful submission before your lordship is that, my lord, during the proceeding also, my lord, the prosecution can produce any number of documents, can, my lord, ask any number of witness to adduce evidences. Only thing is, my lord, that the prosecution must follow the principles of natural justice and there should be, my lord, adherence to the fair play. Adequate opportunity should be given before adducing any evidence.
Yes. You want to give a compilation?
My lord, compilation of judgment or and any written notes of argument if your lordship asks.
Notes of argument is not required, but
Very well, my lord,
if you want you.
my lord, by tomorrow, my lord, I can give the even by today, my lord, kindly give me a second.
You give it properly with pagination like
Yes.
he has given.
Kindly give me a day's time, my lord. Tomorrow, my lord, I shall hand over.
Right. We'll just record.
Whether your lordship will take up the appellate side or original side.
No, first 2 p.m. will take up. Whatever is fixed at 2 p.m. will take up. Original side. Original side.
The appeal, my lord, where, my lord, I had substantially, my lord, concluded my hearings, my lord, to recall, my lord, this is, my lord, against Industrial Development Corporation.
Oh, that transfer fee.
My lord, the 2 points which I had taken, my lord, will recall, my lord, that, my lord, the original, my lord, lease was and still being held by a company called Ram Sarup Industries Limited. It was really in the name of a unit, but unit is not, my lord, legal entity.
Substantially, if we remember correctly, point us out if we are wrong. There were few submissions. You said one is that the plan which was approved, it is binding on the WPID.
Yes.
That
yes.
was the first submission.
Correct.
Second submission was that obviously that there is no change in ownership.
Correct.
The company continues.
I'm grateful.
And there was another submission.
Well, no, those were the two, sir. Absolutely correct. Well, in the second submission,
Yes. Yes.
so the second submission inherent in that was, my lord, first of all, my lord, the West Bengal Industrial Development Corporation in their demand proceeded on the basis, my lord, there's a transfer of lease. There's no transfer of lease. And by change in shareholding, that's where, my lord, I cited those judgments.
You relied on the judgment.
Yes, yes, to show, my lord, that the transfer of a share
One or
in a
two
company
judgments of the Honorable Single Bench and one or two.
and division.
Yes.
Correct. I'm so grateful, my lord. I was, my lord, because such a long time, and then, my lord, it was fixed. I think one day, my lord,
I'm myself surprised that I still remember. Yes.
my lord, I'm just putting it, but I think, my lord, so that, my lord, I was, my lord, facing the judge. And sorry, my lord, just to finish that point. So I had, my lord, submitted that in view of the judgments and the position of law that a corporate entity, just because there is a change in shareholding in the corporate entity, and in this case, particularly by reason of the resolution plan, there is no transfer of lease. If one looks at, my lord, the 422, where, my lord, the challenges to that letter in volume 4. Volume 4 to the it is addressed to, my lord, SS Natural Resources Private Limited, who was one of the successful resolution applicant. The lease, my lord, is in the name of, let's see, we write to you in respect of the sublease dated 3rd September 2009, entered into by and between West Bengal Industrial Development Corporation Limited and Ram Sarup Low, a unit of Ram Sarup Industries Limited. This was one of the corporate debtor. With respect to the land at measuring such and such, demise land. As per policy of WIDC, consent for transfer of subleasehold rights can take place only upon payment of transfer fee. Computed rate of 10% of prevailing market value of the demised land by the transferee to WIDC. Hence, your request to make payment of 6 crore 45 lakhs only being the transfer fee assessed as on 26th October 2021, that is 10% of prevailing market value of demised land to WIDC in order to obtain consent permission for transfer of sublease in favor of SS National Resources Private Limited, SS National. And then, Mullah, just show the reply and then immediately, Mullah, come back to Mullah, where I was going to judgment, page 424. Paragraph 1, the last line of paragraph 1. This land was subleased by WIDC on 3rd September 2009 to Ram Sarup unit of Ram Sarup Industries Limited. Then 2 Ram Sarup Industries Limited underwent insolvency proceedings under insolvency and bankruptcy code, wherein SS Natural Resources Private Limited emerged as the successful resolution applicant. Resolution plan of SS National was approved by Committee of Directors on 16 March, 74.41% voting share, including WIDC is one of the dissenting financial weight. Then, as per terms of the resolution plan, and it's voted, it may not be more very important now. Then we say paragraph 3 asks for waiver, approve the resolution by paragraph 4. Then kindly paragraph 5 very important. Mere transfer of shareholding of lessee company cannot be termed as a transfer of the lease. Paragraph 5. Unless the lease deed expressly makes such specific inclusions, the change in control will be considered as a deemed transfer. And on that ground, Mulad will kindly come to paragraph page 427. I placed all this. I'm just Mulad coming back, Mulad. But I think Mulad remembers Mulad the arguments. Mulad, I don't know Mulad again talk my law. Paragraph 14, page 427. Insolvency and bankruptcy code has been enacted to enhance the ease of doing business, facilitating a resolution process of company in distress and experiencing a serious threat to its continuity as going concern. For this purpose, the COC in its commercial wisdom has been empowered to rescue company so that the entire process of resolution can offer a fresh stage to the resolution applicant, so that new applicant can do the restructuring of the corporate and closed unit, revive its economic worth over stakeholders is largely maximized. Further, in terms of the insolvency and bankruptcy regulations, corporate data shall remain as it is and therefore shall continue to exist with all rights that prior to commencement of corporate insolvency process on all its assets, including its rights over the demised land. Well, the only other thing they had relied upon, that's maybe perhaps that's the 2.5 points which I had also addressed. Page 435, will find this is their this is the
435.
435.
For this, you said it will have prospective application.
Yes. That was the third point, which I had made us.
Yes.
Because this cannot come in the way of a lease which was entered into much before. I'm so grateful, because now in the impugned order, what I was facing, I think was considering from the memo of appeal, if I'm not mistaken. The order of 9th February 2024. Unfortunately, for me, the learned judge, I would most respectfully submit that perhaps the learned judge misunderstood my submission and my learned friend also. I was not on the question. I did not say that only because there is an approval of the resolution plan, therefore you cannot charge any transfer fees, because there were certain clauses which was there in the resolution plan. My argument was, and will recall, my argument was that this was also a live issue, because actually SS Naturals wanted to back off from the plan, saying that I will be charged more. WBIDC will raise all these issues if I go ahead with the plan. NCLT said nothing doing, NCLAT said nothing doing. And in that, WBIDC had argued through the COC, saying that no, there's no question of charging you any transfer fees. So those paragraphs were
Where have they argued this?
Kindly look at in the NCLAT judgment.
Before the NCLAT?
Yes.
Where is it? Can you show us?
Yes, page 310. But it's the judgment. Because they're also part of the committee of creditors. And I placed those.
That will be volume 3.
Yes, volume 3. And it went down as if that was a finding of the court which I was relying upon. But kindly come to kindly similar paragraph 10.
Which page? Sorry.
My lord, page 324, paragraph 10.
10.
Yes. Page 324. my lord.
We have it.
Yes. My lord, kindly see, in reply to the above, resolution professional contends that the appeal is solely premised on the ground. My lord, this was my appeal. That a waiver sought from the adjudicating authority in his resolution plan has not been granted. The SSN, which is my lord SS Natural, has sought transfer of the lease of the land of about 314 acres lying in Kharagpur to Ramsarup Industries. SSN has contended that the adjudicating authority has not sanctioned the waiver on transfer or payment of any fee, consideration, premium areas of lease rent or penalty or interest. Therefore, the resolution plan has purportedly become unviable and unfeasible. Then, as per clause 15.3, 15.12 and clause 54.146G, resolution plan, if the waiver sought are not granted or the assumption made are not true, it will not have a bearing on the successful implementation resolution. COC has approved the resolution plan, fully aware of this clause in resolution plan. Adjudicating authority has not in any manner mandated or directed SSN to make payment of the transfer fee, consideration, premium, areas of lease rent, penalty, interest, or any other payment to WBIDC. Then, my lord, kindly come to.
So this was a submission.
This was my submission. Then, my lord, kindly come to paragraph 21. The learned counsel for the respondent of 5, which is one of WBIDC, who's one of the respondent here, submitted that the appeal is misconceived and premature. Appellant, which is me again, sorry, my lord, page 329.
We are there.
Paragraph 21.
Yes.
Learned counsel for respondent of 5, WBIDC submitted, appeal is misconceived and premature. The appellant has neither any actual cause of action nor is aggrieved by the impugned order in any manner. The appeal is entirely premised on the appellant's apprehension that it may have to incur additional expenses provided it has to comply with the statutory obligation under the resolution plan. Then, my lord, 22, very important. Learned counsel for COC and my lord, WBIDC is also a part of the COC. And they are the only ones, my lord, who receive payment, my lord, under this order as well. Learned counsel for COC contended that the waiver from payment of transfer fees, penalties, and arrears are payable under the sublease deed, as the sublease right of the Kharagpur land was granted to by the WBIDC to one unit of the cooperative, namely Ramsarup Lohodyog, which was merged with the respondent 1 way back in September 18, 2008. Therefore, there cannot be any requirement of payment of any transfer fees as contended in the absence of any transfer. Accordingly, objections raised by the appellants are untenable. Learned lease deed entered into between WBIDC and cooperative unit does not contemplate any transfer fee. WBIDC, next in the next line, my lord. WBIDC, being a member of the committee of creditors, were aware of all terms and conditions of the plan and have therefore voted in favor of the plan. Accordingly, it is now stopped from claiming what it has already waived in the plan, which has even received the adjudicating authority's approval. And then, my lord, also 26. Page 332.
So at the time of passing of this order by the NCLAT, the demand was not in existence.
Thereafter, my lord, the demand came in. Correct. ये क्या था 10% sublease? No, I'm sorry, my lord. Let me just see what the 26th April 2022. No, this demand, my lord, was not there. Because what we are challenging, my lord, is 26th April 2022. Then, my lord, paragraph 26 also, page 332. Thus, in view of the above, appellant or WBIC cannot be permitted to disturb the resolution plan, a resolution process on the basis of mere apprehension of the additional cost of erroneous and subsequent claims which are an afterthought the same could be against the object of the INBC code. Therefore, the principle laid on the above mentioned case, which has been relied upon by the appellant and WHC, does not find a place in the premises discussed above, thus is not applicable in the facts of the case. So I am not saying, it is also not my contention that the NCLAT has held that you are not paying. WBRDC cannot make any claim. But it seems, well, in the NCLAT, this was also an argument which I had made, saying that I will be subjected to more expenses. To the WBRDC and COC said, no, of course not.
So the demand had not been quantified,
No.
but you were conscious that it would arise.
Yes, and I raised an issue, but it was turned down. Saying, sorry, there's no. Now we are on the fact now that whether WBRDC can raise or not. So that is one chapter which is gone. Because I am showing the law says if there's a transfer of the shareholding interest, there is no transfer. And this was Malad further, Malad wants to look at Malad the NCLAT Malad 335, Malad will also find page 335. Paragraph 35. Because what had happened, Malad, I had asked for waiver, thinking Malad that I have to pay. Now they came up Malad and resisting the plan. They said, no, nothing, you don't have to. Where is the question? WBRDC say it's premature. COC and WBRDC together said that no transfer fees because it is only Ramswarup Industries Limited which is there. And then Malad paragraphs 35 and 36.
Some clauses of the resolution plan have been referred in this order.
Yes. Where Malad had asked for waiver. But that has not been, let us Malad assume that's not been granted. We have to see Malad the demand in the context of on what basis have you raised the demand. And that is why Malad before the learned single judge we argued all points. All the 3 points. Saying that if it's a transfer in accordance with the resolution plan, I can't be imposed with additional transfer fees. Secondly, I said even if shareholding is transferred, which is Malad remembers that with all those judgments, Malad, including division bench of Malad our courts, saying that you're not liable. And thirdly, saying the policy which you rely upon, that's a 2012 policy and the leases of 2009. So these are Malad the 3 issues which we urged. Now, my lord, coming back to the impugned order, my lord, will see, my lord, I'm sorry, but my lord, the learned judge, my lord, seems to have, my lord, not considered, my lord, the other 2 points at all. It, my lord, starts, it just immediately after, my lord, the memorandum of appeal, my lord, the impugned judgment is there. First, my lord, paragraph 1, writ petition prayers are quoted. Paragraph 2, my lord, is on the factual aspect, my lord, of POC. Then, my lord, kindly take paragraph, my lord, 4 at page 4. Sorry, my lord.
Paragraph 4.
My lord, it starts, my lord, immediately
Page
after.
4. Page 4, paragraph 4.
Page 4, paragraph. Before that, my lord, the facts, as I've said, my lord, are there. Kindly see paragraph 4, page 4. First petitioner received a letter from the first respondent on April 26, raising a demand for transfer fee of 10% prevailing market of Kharagpur land, quantifying such demand at 6 crore 45, despite there being no transfer warranty transfer. According to the petitioners, respondents were duty bound to ensure transfer of the sublease in favor of the petitioner without payment of any fee, consideration, premium, etc. in terms of clause 15.15.5 resolution plan. Then next, kindly see this is the third point. Land allotment policy introduced by an order dated 26 is prospective in nature, neither applicable to the existing lease, not to the proceeding in insolvency and bankruptcy court. Point, my lord, is clearly taken. In the deed, there is no provision for transfer of the plot by sublease or charging fee for the same. Ramsharup Lohit having merged with the corporate, question of transfer of demise line did not arise, since the corporate debtor was the legal entity and Ramsharup Lohit its unit. Mere transfer of shareholding of the lessee company under the code cannot be termed as transfer of lease, and in any event, the impugned demand and threat of termination, coercive action are beyond the scope of the approval, cannot be demanded in the first respondent. So, my lord, second point also taken, transfer of shareholding is not, my lord, a transfer of lease. Then, my lord, as envisaged, we can, my lord, skip over paragraph 4, then 5. Kindly see, my lord, the judgments, my lord, which we have relied upon. Paragraph 5, my lord, page 5. Learned Counsel has placed reliance on the authorities in Ghansham Mishra and Sons Private Limited versus Edelweiss Reconstruction Company Limited, reported in 2021, 957. And SR Steel versus Satish Kumar. SPS rule. No, my lord, Satish Gupta, my lord, these are the judgments which says clean slate, no further demands, my lord, after, my lord, a resolution plan, my lord, is approved. These are, my lord, the judgments on that proposition. Then, my lord, kindly see. Online, then SPS Steels Rolling Limited and others versus Essential Durapur Development Authority. This is, my lord, on the question of no transfer fees. Then Greenheart versus State of West Bengal. Again, my lord, no transfer fees, my lord, when there's a change in shareholding. Then Din Chemicals and another versus State of West Bengal, reported in 2012 SEC Online, and State of West Bengal versus Gopi Vallabh Solutions Private Limited. All these judgments, my lord, are given. Then, my lord, challenging 6, the maintainable writ petition. Learned Counsel for the respondent submitted. Petition have not come before this court with clean hands and have sought to mislead the court by distorting facts of which the writ liable to be dismissed. Though the petitioner sought to make out a case that demand raised by the WS grossly against the orders passed by the learned NCLT, learned NCLT Honorable Supreme Court, fact remains, petitioners failed to obtain orders in their favor from all the aforesaid judicial forum and have misinterpreted the orders passed by them with the view to obtain order in the favor of the petitioner. I'm sorry, my lord, pausing here for a moment. I have made all those 3 points. Where is the question of, my lord, trying, my lord, to mislead the court, my lord, by obtaining, my lord? Counsel has taken this court to clause 15.3 of the resolution plan, which demonstrates that if the approval, the extinguishment of waiver sought under Annex 3 are not granted, it will not in any way jeopardize the implementation resolution plan. Resolution applicant shall remain responsible for such implementation resolution plan. Clause 15.12 says, even sought under Annex 3 are not granted, same will not have a bearing on the successful implementation resolution plan. Then 7, 15.15.5 was not allowed by the learned NCLT, against which the petition preferred an appeal. Before the learned application filed by the petitioner along with other applications dismissed by the learned NCLT, appeal preferred against the said order also dismissed. Then submission made by the petitioners before the NCLT has been closed as observation of the NCLT in the writ petition. I don't know how that happened. It is crystal clear from the orders passed by NCLT and declared that clause 15.15.5 the resolution plan was not accepted by the forum, despite which the petitioner sought to make out a case. Said clause was accepted by all the forum. Also, the WC raised demand of transferring gross violation of the law. Then reply given by the respondent to the petitioners on 6 July recorded that NCLT's order plus from September 4, 2029 left it to the authorities to consider the request of the resolution after waiver executor of any dues, fees, liabilities. This letter also records that pursuant to the order dated December 26, 2012, WBRDC has framed the terms and conditions of allotment of land module, and the same is applicable to all lease deals, including the sublease dated September 3. I don't know how a order of WBRDC changes contractual relationship. Learned Counsel placed reliance on authority K.D. Sharma and others reported 2008 12 Supreme Court cases, Madras Bar Association in Union of India reported in 2015 8 Supreme Court cases, and Vijay Sal and other versus State of Punjab in support of his contention. Then consider the rival contention of the parties and material record as well as the law on the point. Paragraph 11. At the outset, issue of maintenance writ petition required to be granted. Petitioners have categorically stated writ petition preferred an appeal against the learned NCLAT in view of apprehension related illegal demand for property transfer fees from the first respondent with respect to the Kharagpur land. Judgment of the learned NCLAT demonstrated that the order of the adjournment NCLT was challenged only to the extent of not allowing the terms contemplated in clause 15.15.5 of the resolution plan, thus making the entire plan unviable and unfeasible. Secondly, paragraphs 24 and 25 of the judgment have been depicted as observation of the NCLAT. But it is not clear whether it's an observation or not a submission. Whereas the submission made on behalf of the COC was recorded by the tribunal said paragraphs. Appellants have incessantly tried to convince this court a waiver of transfer is approved by the NCLT and CLAT and the Honorable Supreme Court, where the fact is otherwise. Waiver as recorded, clause 15.15.5 the resolution plan was not approved by any of the forum. Unanimously held that such waiver was left open for determination of appropriate authorities applied for. Therefore, it is crystal clear that the petitioner made an attempt to obtain an order in their favor, misleading the court and misconstruing the contents of the order passed by the NCLT and CLAT and the Honorable Supreme Court delivered. The other 2 points are not even considered. Then, my lord, 12. Honorable Supreme Court has replicated such practice time and again. Was with the Honorable Supreme Court, authority in K.D. Sharma. Santa, then, my lord, goes on, my lord, suppression. I don't know how, my lord, that happens. Because if you try to, my lord, interpret an order, in any event, my lord, can't be suppression. My lord, can you look at paragraph 13? At page 9 is only on the question of the NCLT and CLAT order. But kindly come to paragraph, nothing else for here. Paragraph 14. Then the clauses are set out. Then page 11, paragraph 15. Again, the order on NCLT and CLAT. Then kindly come to paragraph 16. I'm sorry, my lord, sorry, my lord, I missed out on showing my lord something. I'm so sorry, my lord. Kindly, my lord, come back. I'm so sorry, my lord. Just kindly come back to page 10 once. Fourth line from the top starts the Honorable Supreme Court.
Page 10.
Page 10, Manoj.
Yes.
And similar the fourth line in the middle, the Honorable Supreme Court. As well as this court has held in various judgments that changing shareholding of a company does not amount to transfer of its leasehold interest on the plot in question, which will cause for payment of permission fees. Now, there is no finding on that. Learned single judge notes the arguments, the cases. Then here also. Then says unless there is express transfer or assignment of a lease in favor of some other party, it cannot be ordinarily said there is assignment or transfer of lease merely because there is a transfer of shareholding. That's exactly what I've submitted. Now I'm also now not sure, my lord, it's because it appears to be finding or my lord, my submission. My lord, we are criticized, my lord, because my lord, we show the submission of COC and my lord, we are told that you can't pass it off as finding of the NCLAT, which my lord, we were not doing. Then, my lord, coming back, sorry, my lord, coming back to paragraphs 14, 15, then 16 at page 12. At page 12, my lord, will find paragraph 16. Therefore, it is crystal clear that since clause 15.15.5, the resolution plan was not approved by the adjudicating authority, and also since clause 15.3 calls for implementation resolution plan by the resolution applicant, despite refusal of the approvals, extinguishment, and waivers, WBRDC has rightly raised demand of transfer to the tune of rupees 6,445 by the letter imputed dated 26 April 2020. In view of the fact it was not approved by the adjoining or by the appellate forum, ratio discerned that down laid down in the authorities relied upon by the petitioner can be distinguished from the present application only upon approval of the resolution plan by the adjudicating authority, that the claims have laid down therein stand frozen and is binding. Case in hand, clause 15. Not approved at all, therefore authorizing not raise the demand notice. Demand impugned. There is nothing on record to suggest petitioners approach the respective authorities for exemption of transfer prior to issuance of the notice impugned. Then 17, in the above conspectus, court is inclined to hold that the notice impugned should conformity with the terms of the resolution plan. There is no legality on confirm. Well, instead of the resolution plan coming to my aid, the learned single judge has thought the resolution plan directs WBRDC to raise the transfer fee on me. With great respect, the resolution plan doesn't come in my aid. Resolution plan also doesn't go in his aid. To say that the resolution plan directed that there should be a transfer fee now imposed by the WBRDC. And that's exactly what we showed. Both WBRDC and COC with WBRDC has said there's no question of any transfer fees. That was the submission which we pointed out. And the learned judge, with great respect, thought, we are saying that no, NCLAT has held that. If NCLAT has held that, then in terms of Ghanshyam Mishra, we were not required to show anything. We have taken two other points. Our contention is that because of a transfer of the shareholding in a company by the process of a resolution plan cannot amount to an assignment of a lease. This is what our submission is. Even it was a voluntary transfer of shareholding right, then also it is not an assignment. That's what our division benches held, our courts have held. And that is the point. And the next point is 2012 cannot retrospectively change a leasehold unless it's a statutory instrument. It's only an order. There's a bilateral agreement between the parties from 2009. You impose an order of 2012 and you say, now I shall charge you transfer fees.
Where is the original agreement?
Sorry, Malad.
Where
Yes,
is
the original agreement, Malad will find Malad at page 78, volume 1. That's one of the lease deal.
Can you please tell us the page again?
Sorry, Malad. 78, Malad. 78. So Malad 78 and then Malad a type copy immediately after that page 79. And this was Malad a 99 years lease. only paragraphs perhaps my lord needs to my lord look at. Paragraph 15 at page 100, clause 15, sorry. And this exact clause, my lord, was interpreted, my lord, in the division bench judgments, my lord, which we had shown. The sublessee shall not, during the term of the sublease deed, assign or transfer the said demised land on any part thereof to any third party. The lessee is, my lord, still Ram Swarup Industries Limited. Only clauses perhaps, my lord, will be relevant, my lord, to look at page 100, clause 15. Then, my lord, page 106, clause 4.
Yes, yes.
But these clauses are not affected because, my lord, there is no transfer. A change in shareholding, my lord, courts have felt is not a transfer. So the corporate identity remains the same. CIN number, my lord, of the company remains the same. The lease, my lord, still continues to be in the same name. And, my lord, the judgments, my lord, I had already, my lord, given. My lord, just wants to, my lord, just have a Gopi Ballabh, my lord, will recall. Division bench of, my lord, our courts. Green Hut was single bench. This one, Gopi Ballabh, my lord, is division bench. I'm sorry, ma'am. Gopi Ballabh was division bench.
Yeah. The second copy of this. So Green Hut is a single judge.
Sorry, my lord.
Green Hut is a single.
Green Hut is a single judge. My lord, correct. My lord, Justice Mukherjee, I think, my lord.
Yes.
Of that.
Then we have Dean Chemicals.
Dean Chemicals, my lord, is also
Single judge, yes.
Honorable,
Gopi Ballabh, Gopi Ballabh.
Chief Justice, that is, my lord, division bench.
Yes, division.
Then, my lord, paragraph 9.
We are not inclined to hold.
Paragraph, correct.
That change in share or holding of a company coupled with will amount to
transfer leasehold into plot of land which will enable.
And paragraph 11 also.
Yes, correct. Absolutely. Okay. And my lord, one more judgment, my lord, can just have a look, my lord. That was also annexed to our notes and referred, my lord, in the learned single judge's order, my lord. That's at page. That's also a division, my lord, as a division. SPS rolling. That's at page. Sorry, my lord. It's 457, correct. Volume 4, my lord, sorry.
No, apart from these judgments, there is any other judgment?
My lord, only, my lord, it is annexed, my lord, to our stay petition.
Okay.
Page 457.
So just a minute, just let us confirm, so
sorry.
we don't miss. There's one Green Hut and then
there's Green Hut.
There is Din Chemicals.
Then Gopi Ballabh.
Gopi Ballabh.
On the
And
question
then
of,
one
my lord,
more you are going to show from
yes,
the brief.
from, my lord, the state petition itself, my lord, copy has been annexed. Volume 4, my lord, perhaps, my lord. Ajay, my lord has volume. Separately, no, it's separately. My lord, I can give a separate copy also.
No, we have, that is why I was sorting it out. Now we have, both of us have. Yes, you are referring to?
My lord, page 457 of volume 4.
It is surplus. Page
457. Since, my lord, this also involved a resolution plan, that is why I'm showing it. No, here, my lord, just one paragraph. Though, my lord, I think, my lord, the other judgments are more apt, my lord, so far as, my lord, we are concerned.
Which paragraph?
But paragraph 2, page 458. So you'll find, my lord, in the middle, about, my lord, 12, 14 lines from the bottom. Petition number 2. Petition number 2 had made payment of the entire amount of rupees 266 crore in terms of the resolution plan and had proceeded to assume control of the petition 1 along company along with its assets and properties. Also took over the management control of petition 1 council. At the stage of seeking permission to mortgage the leasehold interest of the premises to the Punjab National Bank, the Respondent 1 had raised the issue of payment of transfer fee in respect of the Respondent 1 had raised the issue of payment transfer fee. This will lease deeds in question and issued the letter 24 June. Petition has deposited said amount and filed the petition. Then, my lord, will find. My lord, here, my lord, there, of course, my lord, in the plan, there was a clause which, my lord, actually said, my lord, waiver, but that doesn't matter. Kindly, my lord, straight away come to paragraph 10, where, my lord, the law is also laid. Reasons, my lord, the Supreme the Honorable Division may choose, my lord. Paragraph 10, page 461. In terms of the condition contained in the approved resolution plan, and also in terms of the law settled. Because in this case, though there was a clause also, and court says also in terms of the law settled by the Honorable Supreme Court, terms of Ghanshyam Mishra and Sons Private Limited, the respondent was not entitled to recover the transfer fees. My submission is not on all 3 counts. They are not entitled to any transfer fees. And the learned single judge, with great respect to the learned single judge, was wrong in affirming only going on the basis as if, my lord, we have only argued that because clause 15.5.5 is there or it was not, waiver was not granted. Therefore, my lord, if a waiver is not granted, that doesn't mean the reverse is given. It doesn't mean, my lord, today, my lord, the NCLAT has said, I'm not granting waiver, but you pay. That can't be, my lord, the counter, my lord, of that, my lord, situation. My lord, those are our submissions, my lord.
Yes.
I'm extremely grateful, my lord. I'm so sorry, my lord, for taking up a little time, my lord. But may I have my lord's leave just for 5 minutes, my lord. I'll just. Yeah.
Not the honorable single judge, while
You
dismissing
represent the WBIDC or
yeah, for
state?
the WBIDC. Only WBIDC is the only respondent.
Yes, sir.
But the honorable single judge, while dismissing the writ petition, my lord, has in fact dismissed the writ petition mainly on the ground of maintainability, and then proceeded to dismiss the writ petition on merits also. Because I took the point there that the writ petition itself is not maintainable. The honorable single judge then endeavored to, my lord, dismiss the writ petition on merits also, my lord. If I take your lordship to the, my lord, I'll be
Maintainability on the ground of suppression of
suppression,
relevant
my
and
lord,
material
because
facts.
these are jugglery of facts, my lord. I will tell you, lordship, my lord, because why I say so, all these issues with regard to transfer fees was very much there before the NCLAT as well as before the Honorable Supreme Court. My lord, lately I have come across the pleadings before the Honorable Supreme Court made by this company that is a successful resolution applicant, and the pleading itself shows that they had raised the same issue before the Honorable Supreme Court, and the Honorable Supreme Court was pleased to turn down their prayers. They said that I am charging transfer fees of above 40 crore rupees. Even my minutes of the meeting was there, and the contention before the learned NCLAT, well, the contention of the COC, which was vis-a-vis the contention made by the WBIDC, I made contrasting submissions before the NCLAT. Well, the contentions have been couched in such words, and I'll show you, lordship, I'll take your lordship to the pleadings in the writ petition where it has been stated that the learned NCLAT was pleased to pass an order. The contention of the COC has been shown, has been portrayed as the judgment passed by the learned NCLAT. I'll just, my lord, I'm in my deepest of respect, my lord, I am solely on the ground of maintainability of this, because this is an abuse of the process of law, my lord. The issue which had gone up to the Honorable Supreme Court, the same issue is sought to be raked up before your lordships, my lord. If your lordship now, my lord, kindly takes, my lord, because the Honorable Single Judge, after taking into consideration, my lord, the facts, my lord, if your lordship kindly takes the impugned judgment in the memo of appeal. My lord, my lord, till my lord, internal page 7 up to paragraph 10 or up to paragraph 9, the contentions of both the parties have been recorded. From paragraph 10, my lord, I have considered the rival contention of the parties and material on record as well as law on the point. At the outset, the issue of maintainability of the writ petition is required to be dealt with. The petitioners have categorically stated in the writ petition that they preferred an appeal before the learned NCLAT in view of apprehension of a belated and illegal demand for purported transfer fees from the first respondent in respect of Kharagpur land. But the judgment of the learned NCLAT demonstrates that the order of the adjudicating authority, NCLT, was challenged only to the extent of not allowing the terms contemplated in clause 15.15.5 of the legislation plan, thus making the entire plan unviable and unfeasible. Secondly, paragraph 24 and 25 of the judgment have been depicted as observation of the NCLAT, whereas the submissions made on behalf of the COC, my lord, kindly mark that that's very important, my lord. The paragraphs 24 and 25 of the judgment have been depicted as observation of the NCLAT, whereas the submission made on behalf of the COC was recorded by the tribunal in the said paragraphs. The appellants have insistently tried to convince this court that waiver of transfer fees was approved by the NCLAT, Honorable Supreme Court, whereas the fact is otherwise. The waiver, as recorded in clause 15.15.5 of the resolution plan, was not approved by any of the forums, and it was unanimously held that such waiver was left open for determination of the appropriate authorities if applied for. Therefore, it is crystal clear that the petitioner made an attempt to obtain an order in their favor, by misleading the court and misconstruing the contents of the orders passed by the NCLAT and Honorable Supreme Court deliberately. The Honorable Supreme Court has seriously deprecated such practice time and again. In the words of Honorable Supreme Court and the authority in KD Sharma.
Yes, that you need not emphasize.
My lord. Thereafter, my lord, the Honorable single judgment in paragraph 12 at the next page, my lord, the last 3 lines of paragraph 12, in view of the above, the court is inclined to hold that the writ petition deserves dismissal on this score. Nevertheless, I proceed to deal with the matter on merits as well.
So on that ground alone, the Honorable
writ
Single Judge
petition
found
was
that it is
Your
not.
Lordship kindly takes up the writ petition, my lord. The writ petition is annexed to the stay application. My lord, in volume 1, pages 57 to 60. Starts from page 41. I'll take your lordship to the relevant part. The lordship got that, my lord. Page 57.
Yes.
So this is the pleading in the writ petition, my lord. If your lordship kindly takes paragraph 9, is the operative part of the order of the learned NCLT. My lord, there is no commas about that, my lord. If your lordship kindly turns to paragraph 10. Apart from the above, no variation was made in the plan by the adjudicating authority. Paragraph 11. The petitioners thereafter preferred an appeal before the learned NCLAT, inter alia in view of apprehension of a belated and illegal demand for perpetuate transfer fees from the respondent number 1 in respect of the Kharagpur land, which if compelled to be paid, would escalate the cost and expenses of the petitioners beyond the amount of rupees 400 crores, on the basis of which the petitioner had agreed to the resolution plan process. The NCLAT, while adjudicating the appeal, being civil appeal number so and so, referred by the petition number 1, was pleased to observe as follows. Your lordship may kindly mark that. The observation of the NCLAT has been, my lord, mentioned in paragraphs 24 and 25 of the order of the NCLAT. I'll take your lordships to that NCLAT's order. It is pertinent to mention that the above mentioned claims from WBIDC are an afterthought, as the same was raised after the appellant apprehended transfer fees payable to the tune of rupees 40 crores. It is also important to mention that WBIDC, being a financial creditor, has not raised any of the claims mentioned above before the resolution professional or the adjudicating authority. In fact, WBIDC voted in favor of the resolution plan without any comment about such claims as stated here in above. The same is an afterthought, quantified and submitted only in its latest submission dated so and so, and these were never placed before the resolution professional. Further, WBIDC had only placed its claim before the COC regarding severity charge, which had been approved. Considering the above, it is clear WBIDC's claim is an afterthought and barred by estoppel, waiver and acquiescence. No subsequent claims are to be considered after the adjudicating authority has approved the resolution plan. The Insolvency and Bankruptcy Code 2016 has been, my lord. I will not trouble your lordship with the entire contents, my lord. These are there. Thereafter, my lord, paragraph 12 at page 60. Paragraph, my lord, these are quotations from paragraph 24, 25, and then
So
paragraph 36.
This judgment, has it been annexed?
My lord, it has been shown to your lordship. My lord, that NCLAT's order. My lord, I'll come to that. I'll come.
The paragraphs which he was
Paragraphs.
reading.
I'll show that those relevant paragraphs. My lord, if your lordship now kindly comes to paragraph 12 at page 60 of the writ petition. At page 60.
Yes.
The said order of NCLAT was confirmed by the Honorable Supreme Court in a civil appeal, being civil appeal number 1142 by an order dated May 4, 2021. But as if the NCLAT had adjudicated upon the transfer fees, and that has been adjudicated by the Honorable Supreme Court. Now, if your lordship kindly comes to the NCLAT's order, my lord, which is very vital. It starts from page 311 in volume 3.
Volume 3?
Volume 3 of the paper book, my lord, is the application. The learned National Company Law Appellate Tribunal's order. It starts from page 311. Lordship got that, you know?
Yes.
Well, this is an appeal filed by the successful resolution applicant, which is the petitioner or the appellant before your lordship. Now, if your lordship kindly comes to page 320, the judgment starts from page 320. Lordship, page 320, 320.
Yes.
My lord, just before paragraph number 2, your lordship will mark, my lord, civil appeal number 995 of 2019. 995 of 2019, that is the appeal. My lord, paragraph number 2, I'll just place before lordship. The brief facts of the case are as follows. The appellant in this appeal is a successful resolution applicant whose plan is approved by the adjudicating authority by the impugn order. Appellant has challenged the impugn order only to the extent of not allowing the terms contemplated in clause 15.15.5 of the resolution plan, thus making the entire plan unviable and unfeasible. The appellant contends, 2, 3, 4, 5, I'll just place. The appellant contends that the adjudicating authority has, while purportedly approving the resolution plan submitted by the appellant, unilaterally makes certain modifications to the plan and increase the outflow of the appellant beyond the sum of rupees 400 crore offered by the appellant in the plan without the consent of the appellant resolution appellant. The appellant has in clause 15 of the plan as part of the additional terms of the plan entirely transfer of the lease of 315 acres of land lying in Kharagpur granted to West Bengal Industrial Development Corporation to Ramswarup Law Udyog, a unit of the corporate debtor, to the respondent number 1, Ramswarup Industries Limited being the corporate debtor, without the payment of any fee, consideration of premium or areas of lease, rent or penalty of interest. However, the adjudicating authority has in its impugn order failed to sanction the same. Consequent to the refusal of the adjudicating authority to sanction this term, the appellant will have to incur an additional sum of rupees 40 crores towards transfer charges as well as area lease rents, penalty and interest, which shall result in the increase in the outflow of the appellant's successful resolution applicant from rupees 400 crores being the maximum sum the appellant had agreed to pay under the approved plan to beyond 440 crores, thus rendering the plan unviable and unfeasible. These are the contention. This was the case made out. Thereafter, the appellant's contention has been recorded on and from paragraph 5. In fact, from paragraph 3 to 9, Lordship may kindly mark that from paragraph 3 to 9 is the contention of the appellant. Paragraph 3 to 9. Thereafter, from paragraph 10 to 20, from paragraph 10 to 20,
yes,
are the submissions of the resolution professional. If your Lordship kindly sees paragraph 10, in reply to the above, resolution professional contents 10 to 20 are the submissions of the resolution applicants. Resolution professional, my lord. Lordship kindly sees paragraph 10 at page 324. Lordship may kindly skip. Then in paragraph 19 at page 328, the resolution professional further submitted. And in 20, it is pertinent to mention that as per the terms of the approved resolution plan, monitoring agency was constituted. So up to 20, my lord. Thereafter, paragraph 21 is WBIDC's contention. Paragraph 21. This is the single paragraph of WBIDC's contention, paragraph 21. Then again from paragraph 22 to 26 is the contention of the Committee of Creditors, that is the COC.
Yes.
22 to 26. And then 27 and 28 is again WBIDC's contention. Now, why I'm showing that, if your Lordship kindly sees, paragraph 24 and 25 has been quoted in the writ petition as being the order of the learned NCLAT. The Lordship kindly sees paragraph 22. The learned counsel for COC contended that the waiver from payment of transfer fees, penalties and arrears and whatever CSC contended is against the contention of WBIDC. WBIDC, in fact, COC specifically contended or submitted against the demand raised by the WBIDC. That is why I'm grateful to my learned friend when he was reading this paragraph 22. The lease deed entered into between, if your lordship kindly sees paragraph 22, last 5-6 lines from the bottom. The lease deed entered into between the WBIDC and the corporate debtors unit does not contemplate any transfer fees. That was COC's contention, that you cannot charge any transfer fees. WBIDC, being a member of the committee, was full aware of the terms and conditions in the plan and had therefore voted in favor of the plan. Accordingly, it is now stopped from claiming what it has already waived in the plan, which has even received that by the adjudicator. But there was a tug of war between the WBIDC on the one hand, COC in the one hand. There was the resolution professional and the successful resolution applicant. And on and from paragraph 29 is the conclusion, my lord. The
Yes.
Lordship has seen that, my lord. If I will take your, I don't want to trouble your lordship with the entire, my lord. For instance, my lord, if your lordship kindly sees paragraph 22, your lordship has just read it. Then, my lord, if your lordship kindly comes to paragraph 23, the learned counsel for the committee of creditors contend that the claim of WBID has only been raised pursuant to the filing of the caption appeal and includes the following components. So it was very well there before the learned NCLAT. It is pertinent to mention, paragraph 24, it is pertinent to mention that the above mentioned claims from the WBIC are an afterthought, as the same was raised after the appellant apprehended transfer fees payable to be the tune of rupees 40 crores. It is also important to mention WBIDC, being a financial creditor, has not raised any of the claims mentioned above before the decision profession of the adjudicating authority. In fact, WBIDC voted in favor of the decision profession plan without any comment about such. The same is an afterthought, quantified and submitted only in status submission, and thus they were never placed before the resolution professional. Further, WBIDC had only placed in its claim before the COC regarding security charges which had been approved. Considering the above, it is clear WBIDC's claim is an afterthought. All along, the COC has been hitting the WBIDC in that submissions. Now, if your lordship kindly comes to page 25, paragraph 25 is also COC's contention. Paragraph 26, paragraph 26 at page 332.
Yes.
Paragraph 26 at page 332 is COC's contention. Then again, my lord, WBIDC's contention is recorded in paragraph 27 and 28. Respondent number 4, WBIDC further contended that clause 15.15.5 the resolution plan is not a mandatory condition. It has to be read along with the other conditions of the resolution plan, particularly clause 9, 4, clause 15.3, clause 17, 19 of the resolution plan could apply to the sublease transfer with respect to the Kharagpur land. A combined reading of these clauses could make it clear that the appellant approached the WBIDC concerning the transfer of sublease and could apply for a waiver of the transfer fees and lease rent, but WBIDC was not obliged to grant such waiver. In the event WBIDC refused to grant that transfers, waiver fees, lease rent, even then the appellant was bound to execute the resolution plan. Well, this was the contention of WBIDC till paragraph 28. 29 onwards, the judgment and the civil appeal, my lord, at page 414, my lord, in the next volume, volume 4, was dismissed. The issue, my lord, the main issue in the appeal was with regard to charge of transfer fees with not granting of clause 15.15.5 of the resolution plan, and thus this particular appeal before the CLAT, my lord, NCLAT, at page 414 in volume 4. 414. Based on the above discussions, company appeals, insolvency number so and so are being dismissed. The contention of the COC with regard to transfer fees, the plea of the WBIDC, the plea of the appellant, my lord, was negated. That they specifically prayed in the appeal. You can have conference. Vociferous. my lord, the plea of the appellant before the learned NCLAT up to the Honorable Supreme Court that they are charging the transfer fees. My lord, this plea was there, very well there. My lord, after this appeal was filed, I sought for certain papers from my office, from WBIDC. My lord, I can get hold of all these pleadings before the Honorable Supreme Court. If your lordship kindly takes up this documents.
That may not be required.
The,
We'll go by whatever is there in the records.
my lord, I just wanted, my lord, for the ends of justice.
Not
because
required, you have quoted everything you have already shown.
my lord, just if your lordship kindly takes the no, because my lord, this
There
is
are two things which you have already argued. One is that misrepresentation or suppression being vitiating the writ proceedings. And the second is which you have just argued. So both things we have heard.
for the end, my lord, if your lordship kindly allows, my lord, then I can, my lord, I
See,
have,
whatever
I have
is not on the records, we should not look into. If it was not in the writ proceedings, why should we
because
look
this
into?
is their appeal, my lord. They preferred before the Honorable Supreme Court while preferring an
They are not. They are
while preferring an intra-court mandamus appeal, my lord.
Today, the submission is not that it is a issue which was decided in their favor by the NCLT or NCLT. They are not saying that today. The single judge records, there it was there. You have shown from the pleadings that they have suggested this. This is a misrepresentation. So today they are not claiming it anyway. So that is not an issue today. Whether that suppression is a suppression or not, that we have to see.
But that's yes, my lord. If your lordship, that separation, my lord. Why I wanted to show your lordship the pleadings before the Supreme Court, because the issue of transfer
See,
fees.
there are two things. That issue of transfer fee is not there in the earlier proceedings.
It was there.
Whether it is a part of the plan or not, that was the issue.
But it was because that was not approved by the learned LCL.
Correct. So whether it was not approved as a part of the plan. Now today what they are submitting, as I could gather, they are saying divorce the plan. It is not a demand which can be raised or substantiated. Please, why are you looking at them? What they are saying today is that it is a demand which is not sustainable for two reasons. The shareholding change in shareholding does not amount to a transfer. The other thing is,
I'll tell you, lordship, my lord. The NCLT
that the policy has no retrospective application. These two things they have
said. Today, my lord, we are not into policy, my lord. Today, I am into the question of maintainability. Then I'll come to the question of
correct.
policy.
So maintainability,
it come first, my lord.
Yes.
As your lordship has laid down the law,
yes,
my lord, the question of maintainability, the question of suppression of fact, the question of distorting the facts is also, my lord, is suppression, and for that purpose also, my lord, the writ petition is liable to be dismissed.
Obviously, equitable jurisdiction.
I'm grateful to your lordship. Now, my lord, when the plan was approved by the NCLT, my lord, the National Company Law Tribunal, my lord, specifically held that clause 15.15.5. I'll take your lordship to those clauses. Clause 15.15.5 is not acceptable. That is waiver of any charges, statutory fees, everything.
They are not disputing that.
I put this question to myself: what forced me, what compelled me to prefer an appeal before the learned NCLAT? The question before the learned NCLAT was only that WBDIDC is charging me transfer fees.
Correct.
NCLAT took up the issue.
Yes.
NCLAT took up the issue, my lord, and said that I am not entering into these questions. Challenging that, they went up before the Honorable Supreme Court. The Honorable Supreme Court affirmed the order both of the learned NCLT and NCLAT, and the issue of transfer fees, which was raised time and again from NCLAT up to the Honorable Supreme Court, my lord, has been now closed for us. My lord, this is a question of issue estoppel.
Therefore, this is not an issue that they are disputing. They say we have done it in the proceedings before the NCLT, NCLAT, and we have gone up to the Supreme Court. It was not incorporated in the plan, but now they are saying otherwise it is unsustainable.
Lord, I'll tell you,
so the maintainability of such a demand divorce the plan. That is what they are trying to argue today. Now, whether they are permitted or not, you can submit. Yes.
What I want.
Yes.
My endeavor before your lordship, my lord, the maintainability of such a plan, such a demand, divorce the plan, was raised before that is what I have been submitting before lordship. The maintainability, my lord, they have raised that this issue, divorce the plan which you are raising now, that is charging of transfer fees, this issue is not being raised for the first time before this honorable court. the same issue
So
was
that is
raised before the learned NCLT,
well taken, yes.
as well as before the Honorable Supreme Court.
We understand
And
what you are saying.
the Supreme Court as well as the NCLT were pleased not to interfere with that.
Yes.
Now, my lord, the question is whether they can raise the same issue before this Honorable Court.
So yes, let us hear you on this point.
My lord.
So there's no issue that it was not argued. Therefore, you need not show the pleading. Whether they can say it again in the writ proceedings that you address.
My lord, because there are specific grounds taken before the Honorable Supreme Court. Even my lord, resolution which I had taken for transfer fees, that was annexed before the Honorable Supreme Court.
That is not in dispute. They are not disputing.
I'm grateful to your lordship. I'm grateful. I'll not trouble your lordship with the pleadings.
No, we don't. We otherwise also we don't want to go into something which was not in the writ records.
Now, if your lordship kindly takes up the resolution plan. The resolution plan starts from page 174 to 238.
Which volume?
Volume 2. Pages 174 to 238. My lord.
This is the plan.
This is the plan, my lord. The relevant clauses, my lord, in this plan is clause 15.3, 15.12, 15.14, that is 6G, and clause 15.15.5. Now, if your lordship kindly comes to clause 15.3 at page 197.
Right. 15.3. Yes, we are looking at it.
On approval of the resolution plan by the identity authority, the resolution applicant shall ensure its effective implementation. However, if this resolution plan cannot be implemented for any reason or attributable to the resolution applicant, then the resolution applicant shall have no liability of this amount, provided, however, as specified in cost of punishment terms, if the approvals, extinguishment, and reverse cost under election fee are not granted, it will not in any way jeopardize the implementation of the resolution plan, and the resolution applicant shall remain responsible for such implementation of the resolution plan.
Yes.
This is right. Thereafter, clause 15.12 at page 199. Concessions, relief, and dispensation sought. The resolution applicant requests for the relief, concessions, and dispensation set out in Annexure 3. Upon approval of the plan by the adjudicating authority, it shall be deemed that the reliefs, concession, and dispensations set out in Annexure 3 have been granted. The resolution applicant clarifies that in the event the aforesaid reliefs, concessions, and dispensations are not granted, the same will not have a bearing on the successful. And our clause 14.15.14 starts from page 199. So the element is 6, that is at page 203. Contracts, your worship got it. 203.
Yes.
At page 2043. Notwithstanding anything contained in the resolution plan, if any of the assumptions specified in this clause are not true or correct, it shall not have a bearing on the successful implementation of the resolution plan, and the resolution applicant shall remain responsible for implementation of the resolution plan.
Yes.
Then comes clause 3. Clause 15.15.5 at page 208. Specific with Kharagpur land. Kharagpur land.
Just give us a minute. Now, yes, you were referring to?
Clause 15.15.5 at page 208.
Yes.
Kharagpur land on sanction of the plan, the lease granted by WBIDC in favor of Counsel over approximately 315 acres of land shall stand transferred to the corporate data in a manner such that the corporate data is still to be in possession and shall have absolute lease rights in Kharagpur. Sanction of the plan by the agency shall constitute the direction of WBIDC to establish ensure transfer of the lease in favor of the corporate data on the same terms and conditions as contained in the existing lease agreement and without the requirement of payment of any fee, consideration of premium. WBIDC shall not be entitled to any penalty, area lease rent, or any interest on arrears, and all such amounts shall stand extinguished waived upon approval of the plan. On and from the date of sanction of the plan, the corporate data shall be distributed in auction and assumed and put a marketable title right of interest on the land. Further sanction of the plan shall also consider the direction of WBIDC to accord expedition and completion of mortgage for the reason of the this was the development plan.
Yes.
For the important clauses in the resolution plan. Now, my lord, how the learned NCLT, National Company Law Tribunal, dealt with the resolution plan. If your lordship kindly comes, the order of the NCLT, my lord, starts from page 239 of this volume 2, which your lordship is looking at. Starts from page 239. But the relevant paragraphs are at volume 3, my lord. That is paragraph 67 and 68. Like,
We have to go to the next volume,
NCLT orders, my lord, it starts from this volume.
but
volume
it goes on to the next volume.
Next volume. It starts from page 239, it goes up to page 309.
So which page you are
Well,
referring?
I am referring to page 296, volume 3. Paragraph 67 there.
Yes.
Form H is not required to be filled. In this case, this application was filed for the amendment to CIRP resolution. We directed the applicant to file a Form H and file the same. The resolution plan that we have by the CIRP except certain legal clause like procedural requirement of the Companies Act, member of any key paper can stop staying private application other than operational dates specified stamp duty and RC fees. In case of increase in the aspect, etc., claim as per the plan which was cannot be approved for the reason that those statutory fees and taxes claim in the case in hand are liable to be paid by the resolution applicant in accordance with law. Any exemption for payment would be given by the respective authorities if applied for. With the above observations, we are not inclined to approve the waiver, but that waiver in clause 15.15.5 as prayed for in the plan. It is left open for the determination of the appropriate authority to apply for the waiver exemption as prayed for in the plan. As per clause 15.3 of the resolution plan, the resolution applicant has given undertaking that if the approvals, extinguishments and waivers sought under section 3 are not granted, it will not in any way jeopardize the implementation of the resolution plan, and the resolution applicant shall remain responsible for such implementation of the resolution plan. The learned counsel admitting for the resolution applicant was asked about the possibility of increasing the distribution percentage offered to the operation creators under the workmanship, who would submit the resolution applicant is unwilling to vary and modify the plan, and the waiver asked for, if not granted, the resolution applicant may withdraw from implementing the plan. We are afraid the said submission is unmindful of the consequences of clause 15.3 in the plan. Thereafter, my lord, the orders is at page ordering motion is at page 301 and 304. I am not troubling you. Page 301 is the order. It goes up to page 304. After this, my lord, the challenge, my lord, this particular order of the NCLT, primarily on the ground that the waiver which has been sought for under clause 15.15.5 was not given, and that they have to bear the additional burden of paying the transfer fees to WPIs. That was the primary ground raised before the NCLT. The NCLT, my lord, took into consideration those. Well, I just pointed out, I just shown it to your lordship, my lord, that at page 320.
Yes, you took us from paragraphs 3 to 9. Yes.
Your lordship.
Yes.
That's what your lordship, that content.
Yes.
Paragraph 2, 3, 4, 5, the gist of that case made out before the learned NCLT.
You have already placed it.
And thereafter, the conclusion is from paragraph 29 onwards.
Yes.
So, my lord, it is very much, my lord, see, very, if I open up the open eyes, my lord, that the case before the learned NCLT was that non-granting of approval of clause 15.5, and they had to bear the additional burden of paying the transfer fees. My lord, the learned NCLT, my lord, had turned down their prayers. They went up before the Honorable Supreme Court. The Honorable Supreme Court's order is at page 416. At page 416 in volume 4.
Yes.
The possible the NCLT in the operating directions as entirely observed as follows. The NCLT's my lord order has been quoted. My lord, the above order of NCLT, my lord, the lordship 9 comes to the next stage, has been affirmed by the National Company Law Appellate Tribunal. The resolution plan was approved by the Committee of Creditors in the commercial wisdom. The resolution plan has been approved by the NCLT in terms of the above directions, save and except for a minor aspect pertaining to the security expenses of WPIDC, on which there is no technical contest on either side. Most substantial questions of ours raised by the appellant, the appeal is accordingly dismissed. But it is not a one-handed dismissal by the Honorable Supreme Court. Their contention before the Honorable Supreme Court with regard to the same issue which was there before the NCLT with regard to charging of transfer fees.
Yes.
The two judgment with Honorable Supreme Court took into consideration, which I placed before Honorable Single Judge. My lord, one is KD Sharma, which is reported in 2008 volume 12 Supreme Court cases page 481. Our copy kotha. Our copy kotha. Gaurav nahi. Sir, all of the issue of maintenance. I relied upon paragraph 27, 34, 734, 36, 38, 39, and 53. Paragraph 27 at page 490. Yeah, please. Paragraph 27 at page 490. Yeah, please.
Just a minute. Yes, 27. Yes.
by playing fraud of the court government authorities and making an honest in the law. Such a judgment will be ordered by the first court of the final court of judgment. Or as an act of deliberate deception with the kind of situation by taking outside advantage of all money is loss and also the certain questions stand different. What is the exclusive collateral act? Whether it's a one person. But there are the paragraphs. The jurisdiction of the Supreme Court of the High Court of 6 is extraordinary, equitable, and decision. Prerogative it's mentioned therein are issued for the substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hands, put forward all the facts before the court without concealing or suppressing anything, and see an appropriate relief. If there is no disclosure of relevant and material facts, so the petitioner is guilty of dismissing the court. If petitioner may be dismissed at the threshold without considering the merits of his claim. Number paragraph 36, the prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court would certainly bear in mind the conduct of the party impose the jurisdiction of the court. If the applicant makes a false statement or suppress material fact or attempts to mislead the court may dismiss the action on that ground alone and may refuse to enter into the merits of the case by stating, "We may not listen to your application because of what we have done." The rule has been evolved with the larger public interest to deter unscrupulous litigants from abusing the process of court by defaulting. Then paragraph 38. The above principles have been accepted in our legal system also. As per our settled law, the party who invokes the extraordinary jurisdiction of this court under Article 32 or of a High Court under Article 226 of the Constitution is supposed to be truthful, frank, and open. He must disclose
on these grounds in para 53, it is dismissed.
Thereafter, on similar ground, 2003 volume 9 Supreme Court cases, page 401. Page 401. (24 to 26). The last page, that page.
Yes, Mr. Mukherjee. Perhaps we will not be able to wind up. Yes.
At page 420, I am referring to paragraphs 24 to 26. That's in the last page of this judgment. At page 420. But my lord, now this number 420 is no more because we have that new Parthian.
Yes.
Paragraph 24. In order to sustain and maintain the sanctity and solemnity of the proceedings in law courts, it is necessary that parties should not make false or knowingly inaccurate statements of misrepresentation and or should not conceal material facts with a design to gain some advantage or benefit at the hands of the court. When a court is considered as a place where truth and justice are the solemn pursuits, if any party attempts to pollute such a place by adopting the court to make representation and is concealing material fact, it does so at its risk and cost. Such party must be ready to take the consequences that fall on account of its own making. At times, lenient or liberal or generous treatment by courts in dealing with such matters either mistaken or lightly taken instead of learning a proper lesson. Hence, there is a compelling need to take a serious view in such matters to ensure expected purity and grace before we part with this thing. We must observe that the misrepresentation made by the appellants supported by an affidavit requires serious action. Thereafter, this cost was imposed. The last line of that paragraph, but we instead of warning to them to be careful in future not to make any misrepresentation or false statement before any court and impose cost also. These were the two judgments which were placed reliance before the honorable single judge also. But only one judgment, my lord, which I will be placing today. 2005, volume 7, Supreme Court cases, page 190. Now, this is with regard to issue of stock.
Why 5 should sub? Hello, paragraphs. I'm sorry. I put 7 Supreme Court cases, page 190. But I'm placing reliance upon paragraphs 14, 16 to 18, 16, 17, and 18. And then my lord, paragraphs 24, 25, and 26. Paragraph 15, the abnormal case at page 197. 5 days.
Yes.
Paragraph Dr. Pasman, just take read out 2 lines from paragraph 18 at page 198. The last 3 lines. At page 198, the principle of res judicata is a species of the principle of estoppel. The proceedings based on a particular cause of action contain finality. The principle of res judicata shall fully apply. Paragraph 24 to 26. Yet again, in Honor versus National Westminster Bank PLC, the House of Lords, what is the distinction between the cause of action estoppel and issue estoppel? Cause of action estoppel arises when the cause of action in the latter proceeding is identical to that in the earlier proceeding. The latter having been litigated between the same parties or the previous and having involved the same subject matter. In such a case, the bar is absolute in relation to all points decided unless fraud or collision is alleged, such as to justifying setting aside the alleged. The discovery of new factual matter which could not have been found or by reasonable diligence for use in the earlier proceeding does not according to the law of England permit the latter to be reopened. Issue estoppel may arise where a particular issue forming a necessary ingredient in a cause of action has been litigated and decided, and in subsequent proceedings between the same parties involving a different cause of action to be the same issue is relevant, one of the parties seeks to reopen that issue. Here also the bar is complete to relitigation, but its operation can be thwarted under certain circumstances, the House then finally observed. But there is room for the view that the underlying principles upon which estoppel is based, public policy and justice, have greater force in which cause of action is stopped in the subject matter of the two proceedings being identical than they do in issue estoppel. But the subject matter is different. Once it is accepted that different constitution apply to issue estoppel, it is hard to perceive any logical distinction between a point which was previously raised and decided and one which might have been
but was not even even then the further material which are put and entirely different complexion of the point was at the earliest stage known to the party not by simple intelligence have been discovered by him. It is hard to see why there should be a different result according to whether we decided not to take the point from this or we will find information without any real hope of success. The point was very much known before the NCLT and CLT. But thereafter, paragraph 25 in Gulabkan Manor, constitutional bench held that the principle of res judicata is also applicable to subsequent suits where the same issues between the same parties have been decided in a proceeding under Article 226. It is tried that the principle of res judicata is also applicable to the writ proceedings. It is always there. It is always there. My submission before lordship that this particular court mandamus appeal, which is a continuity, my lord, continuation from the writ proceeding, and in the writ petition specifically it has been stated that I have been that there is a specific pleading to that effect, and which has been affirmed as to the knowledge that I have been granted this leeway by the NCLT that I am not supposed to give that transfer fees has been specifically pleaded.
Yes.
And taking note into consideration those paragraphs, the Honorable Single Judge in my humble opinion has rightly dismissed the writ petition on the ground of maintainability. Well, then after the Honorable Single Judge proceeded to dismiss this by taking into consideration the merits of the case. But on that score only, my lord, the writ petition was not maintainable. The writ petition had to be dismissed. And the Honorable Single Judge ought not to have ventured further in this matter. The same issue is sought to be raised again and again. My lord, I have been, my lord, reiterated, my lord, I have stated the same thing. From the NCLT, there was a plan. The plan was not, my lord, it is entirely approved by the learned NCLT. My lord, there were certain, my lord, changes, modifications made. Clause 15.15.5 was not approved by the learned NCLT. Challenging that, they went up before the learned NCLT, saying that they ought the learned NCLT ought to have approved clause 15.15.5, whereby they were not supposed to pay any fees, any statutory charges. And they had also specifically pleaded before the learned NCLT that I will be paying a further sum over and above the sum of rupees 400 crores as transfer fees to the WBIDC. WBIDC made this contention. COC made contention in contrast to the submissions made by the WBIDC. So we said no, WBIDC cannot charge it. The learned NCLT took into consideration the submissions made by the successful resolution applicant, the RP, the COC, as well as the WBIDC, and came to the conclusion that this appeal, well, they did not interfere with the appeal and the appeal was dismissed. Challenging that, assailing that particular order of the learned NCLT, they went up before the Honorable Supreme Court, and the Honorable Supreme Court also, my lord, did not enter into the motion. My lord, I wanted to place before Lordship, my lord, it is before the Honorable Supreme Court, because it is not there. It was not there before the Honorable Single Judge. Because the Honorable Single Judge, all along the submission was made with regard to maintainability. He did not exchange any affidavit. It was not required at all.
Not required. This is not a fact in dispute. They are not saying that they are not saying that they have not taken up this issue up to the Supreme. They are not saying. Yes.
This eloquent submissions has tried to discuss before lordships. By saying that we are not saying that the transfer fees was not a subject matter between the learned NCLT. But what we are saying that those issues were not touched by the NCLT. NCLT, what I can take out from the submission subject to condition of learning, my lord, that the NCLT, though has not allowed our prayer, has also not given any permission to the WBIDC to seek transfer fees. Lord, that is what the issue is.
That is, he has said so.
Before your lordship, these issues were raised, very much raised before the learned NCLT. Those are according the order of the learned NCLT. And the NCLT, even after taking into consideration those issues,
was pleased not to enter into the same. Now, my lord, question is after going up to the Honorable Supreme Court, whether they can raise this issue before this Honorable Court.
Correct.
My lord, there has been a merger. The Honorable Supreme Court has not passed an one-lined order. The Honorable Supreme Court was pleased to observe that the modifications made by the NCLT and approved by the NCLT
Yes.
were correct, and the Honorable Supreme Court was pleased to dismiss the civil appeal. There has been a merger. Whether I put this question to myself, whether the same issue can be raised again before this Honorable Court. There are specific pleadings. My lord, we had filed our statement submissions before the NCLT, even before the Honorable Supreme Court. My lord, though I do not get this opportunity to place all these papers. There are pleadings that they are charging me 40 crores and above. It is not that the learned Honorable Supreme Court granted them liberty that you raise the issue of particular this transfer fees before any forum. For that, sorry. But these are the humble solutions because if the lordship is not at one with regard to credibility, then only the issue of this merit will come.
So both issues here.
It has to be met in the one, it was not maintainable at all. And consequently, my lord, the appeal is also not maintainable.
So that you have confined only to these two things.
Even before the Honorable Single Judge, my lord, I made my submission only with regard to the maintainability. Honorable Single Judge was of the view that it is not maintainable. Went ahead, my lord, thereafter, my lord, to discuss the same on merit also. I say, but it is not maintainable. You cannot take up the same issue.
And on the other submissions, you don't want to say.
But I do not wish to, my lord, distinguish all these judgment Gansha merit because, my lord, if on the count of maintainability, it is not, my lord, maintainable. My lord, because I stick to my ground, my lord, it's not maintainable. Not maintainable. I did not, my lord, venture into this.
On two grounds. One is the suppression or misrepresentation, and another is that it has attained finality up to the
suppression by receiving words, my lord. The pleadings were clear from the pleadings.
soiled hands in substance.
It is clear from the words. My lord, they cannot take up the same issue here. My lord, two brothers. I'm grateful to your lordship.
Yes.
Giving me a patient. May I take a question, please, for 5 minutes?
I'm going to take the first judgment which my learned friend cited. The KD Sharma.
Yes.
2008-12 Supreme Court cases 481. And kindly take paragraph 15.
15.
Yes. I don't think, I have any dispute, with the proposition of law, which has been laid down, in both these cases, the first two. But kindly look at, what was, this was a case of suppression. Now, kindly look at, paragraph 15. Mr. CM Ramesh, Chairman and Manager of Rithvik Projects, who was earlier, page 487.
Yes.
Who was earlier representative of the appellant and in whose favor appellant had issued a power of attorney, had joined hands with respondent number 2 and was virtually won over by him. The appellant had also revoked and withdrawn the power of attorney issued in favor of Ramesh, and obviously therefore he had no authority to represent the appellant and could not have appeared either before sale for negotiation for him or entered into any compromise or settlement on behalf of the appellant. 16. It was contended that though for a substantially long period applications for recalling of order instituted by the appellant had not come on board and he had to approach this honorable court making grievance about non-hearing of the matter, there was no progress whatsoever. It was only after the order passed by this court, which is not the Honorable Supreme Court, affording an opportunity to respondent stating that if he would appear, an appropriate order would be passed, that the respondent too got the matter hurriedly disposed of in the High Court. Then 17. It was the allegation of the appellant that at the time of hearing of miscellaneous cases, a new advocate appeared on his behalf who was not engaged by the appellant. Some blank papers on which the appellant might have signed earlier came to be utilized for the purpose of making applications for settlement, showing that the appellant was agreeable to such settlement. The settlement was produced before the court, and on that basis, the matter was finally disposed of on the assumption that all the parties are compromised and amicably settled the matter, and nothing was required to be done. Accordingly, all three miscellaneous petitions 46, 48, 47 of 2004 were disposed of. Submitted that in these circumstances, order passed by the High Court deserves to be quashed and set aside by remitting the court matter to the High Court so that the recalling application file decided afresh after hearing of the parties. Well, I am sorry, my lord, I don't know, my lord, how this is relevant in so far as we are concerned. And my lord, kindly look at, my lord, paragraph paragraph 33. What is one of the fraud, my lord, which was committed? This was only the case he went with. Then, my lord, kindly see paragraph 33, page 491. The learned counsel for sale is also right in urging that the appellant has not approached the court with clean hands by disclosing all facts. An impression is sought to be created as if no notice was ever given to him, nor was he informed about the consideration of cases of eligible and qualified bidders in pursuant of the orders passed by the High Court in review and confirmed by this court. True facts, however, were just contrary to what was sought to be placed before the court. Notice was issued by sale to the appellant. He received the notice, intimated in writing to sale that he had authorized Ramesh of Rithvik Projects to appear on his behalf. Ramesh, then page 492, Ramesh duly appeared at the time of consideration of bids. Bid of respondent 2 was found to be lowest and was accepted, and the contract was given to him under tender notice 4. Said contract had nothing to do with tender notice 5, and the contract thereunder has been given to appellant herein, and he had completed the work. Thus, it is clear appellant had not placed all the facts before the court clearly, candidly, and frankly. Then, my lord, 34, jurisdiction of Supreme Court under 32, High Court 226 was extraordinary, equitable, discretionary prerogative is mentioned at Sunsatch, issued for doing substance, therefore almost necessary, petition of the court, come with clean hands, put all that, my lord, is known. Then, my lord, paragraph 52. Page 497. In the case on hand, appellate does not come forward with all the facts, chosen to state the facts in a manner suited to him by given impression with court that an instrumentality of state sale has not followed doctrine of natural justice and fundamental principles of fair procedure. This is not proper. Hence, on the ground alone, appellant cannot claim equitable relief, but we'd also consider the merits of the case, and even on merits, we are convinced no case has been made out by him to interfere with the action of sale for the or the order passed by the High Court. Now, my lord, here in the writ petition, we have disclosed all the court, the orders of NCLT, NCLAT, the resolution plan, and the Supreme Court. We might have sought to put an interpretation to the court orders by saying that, look, you have raised the point, this was not entered in neither on my ground nor on your ground. Therefore, you cannot raise it. Court might have disregarded and said, sorry, I'm not accepting your submission. But where's the question of suppression or fraud? And I've shown, my lord, in the judgment itself, 3 points were taken.
Yes.
But when my wrong interpretation of an order of court, which I've disclosed, cannot be, my lord, a question of fraud. But I am joining, my lord, issue with my learned friend by saying, my lord, when he says, I might wrongly interpret an order. Court will say, sorry, you're a fool, you have not been able to interpret the order. Where's the question of fraud or suppression? And that's why I started by saying, my lord, kindly, my lord, the first order, to the extent,
Yes.
neither will, my lord, it help me, the enclad order, nor, my lord, will it help him. Because now, kindly see, my lord, what my learned friend is doing, he's saying, no, the NCLT order directed that he should pay. My lord, today, my lord knows the NCLT is only considered, and that is what it was. NCLT is only considered with whether the resolution plan is legal or not within the framework of, my lord, the IBC. When I went and said, look, I will impose with all this liability, they threw us away. They said, sorry, you have accepted the plan, you have accepted the plan. When they also went and said, no, nothing is due and payable. NCLT is not decided. Now what my learned friend is saying, he wants to expand the scope of NCLT to say that as if NCLT has decided that I will have to pay this transfer fees. I'm really sorry, my lord, but that is not what, my lord, is within the jurisdiction of the NCLT, nor has the NCLT held that.
They are not saying that NCLT has decided you have to pay. They say you have taken up this issue before the NCLT, NCLT and Supreme Court.
Correct.
And you have not succeeded.
I'm not.
They are not saying that there is a mandate by the NCLT or NCLT.
My lord, to that extent,
perhaps that is not their argument.
My lord, I am grateful. My lord, then kindly consider
Estoppel, correct. They said that you have tried this. That is their case.
Correct.
You have already tried this.
Estop means,
The same issue.
my lord, estoppel means, my lord, it has to be decided. It has not been decided. Kindly, my lord, appreciate, my lord, he cites a judgment of res judicata.
Yes.
Res judicata means, my lord, that res has to be decided by the NCLT.
He is on issue estoppel. He is on issues.
Same, my lord, issue estoppel, res judicata, it's a species.
So he is on that.
So I'm also, my lord, I'm saying, my lord, for that, my lord, the NCLT would have to decide the issue that your demand for transfer fee, which you raise subsequent to the resolution plan, is a justified demand. And with great respect, my lord, I did not find, and nor could the NCLT ever decide that a post-resolution plan transfer fee which you are going to ask for, we have decided that it is legal. So there has to be a decision. My learned friend can't say I can't raise this issue because that issue was not decided there. I had raised the issue that I want to walk away from the resolution plan because I'll be imposed with this liability. They said nothing doing, you are bound by the plan, you have to accept it. And that in that context, my lord, I showed their submission where, my lord, they say it's premature. WIDC itself says it's premature. And COC along with, my lord, WVDIC, my lord, WIDC is also a part of COC, said no, you cannot. That's their submission. I don't know how, my lord, issue is trouble. My lord, kindly look at, my lord, the just to the other judgment. My lord, even in Ishwar, my lord, Ishwar Dutt, in Ishwar Dutt also, my lord, paragraphs. My lord, here, my lord, there was a question of, my lord, suppression. No. Oh, sorry, not Ishwar Dutt. Is the other suppression? Correct.
There is one Vijay Sayal.
Yes. That's right. My lord, Vijay Sayal, yes, my lord. Vijay Sayal. Lord, kindly look at that. Paragraph 24 itself, my lord, records. Paragraph 24, Placidum B, should not conceal material facts. Paragraph 24, my lord, at page 420. Let's see, in order to sustain, maintain the sanctity, solemnity of the proceeding law code, and necessary that parties should not make false or knowingly inaccurate statements or misrepresent and or should not conceal material facts. With the desire to gain some advantage with benefit and to the court is considered placed by truth and justice solemn. That's why I said, my lord, I'm not saying, I've not said, my lord, I've not concealed any material fact. I've not misrepresented. I'm only saying this is the argument which I'm making. You may not agree with my argument, my lord, on the first point. I have 3 points. If you reject me on the first point, on my interpretation, doesn't mean, my lord, my second and third point go away. And in Ishwar that, my lord, kindly see, my lord, this is very important. Now, what my learned friend, my lord, this is obviously, my lord, it was not argued, my lord, before the first court. Paragraph my lord, kindly come to, my lord, paragraph 14. At page, my lord, 197. In fact, my lord, sorry, my lord, may I just trouble my lord once, my lord, with at page 192. I see. Paragraph page 192, where the facts are not given. Article note as received. 99, not in dispute, High Court issued a writ of mandamus directing respondents to pay the registrars interest at 12% per annum. The date of taking over possession of the acquired land to the date of payment of interest compensation. Further directed that such interest was to be addition to the compensation, solation interest at the statute rate which would be paid to the writ petitioner under law. Whether awarded by the collector or enhanced by the court, such interest would not be taken into consideration in any proceeding under this act while awarding the statutory compensation. It is also not a specific direction the High Court was acted upon. Question that an amount other than one envisaged under section 223 1A of the Act, the Act would not be granted on equitable grounds was not raised by the respondents, although having regard to the decision of Supreme Court in Dharamdas was available to them. As the judgment and order passed in SWP number 1098, respondents herein should not have raised any contention contrary thereto or inconsistent with any subsequent. In fact, land acquisition officer, while part of the award 31 in consideration, said direction and awarded 12% additional compensation at the market value. State could have filed an application under section 8 thereagainst. It did not choose to do so. Only the appellant hearing took recourse to the said provision, culminating passing the impugned judgment of the court. Thus, the award of the land acquisition officer directing payment of additional interest is also at finality. Therefore, in the section 18, a reference filed with the appellant against the above award or in the first appeal filed there against under section 54 of the Act by the respondents. Reference to the High Court external appellate jurisdiction, section 52 Act, did not have dealt with the said question. My lord, here, my lord, we are NCLT, my lord, deciding, my lord, on the question of, my lord, the plan, the resolution plan. It does not have any jurisdiction. And in this context, my lord, sorry.
Yes.
In this context, my lord, can you look at paragraph 14? not in dispute. High Court issued a writ of mandamus. It is also not in dispute. Direction to High Court is acted upon. Principle of res judicata is well known. Would apply in different proceedings arising out of the same cause of action, but would also apply in different stages of same proceeding. As the judgment and order passed in CW number 510 of 1998 finality, we are of the opinion that the respondents hearing would not have raised any contention contrary thereto or inconsistent therewith in any subsequent proceedings. In fact, the land acquisition officer, while passing the award on 31/1/1991, took into consideration said direction, awarded 12% additional compensation. Said order of land acquisition officer never came to question, thus attained finality. Section 18 of the Act provides any person who has not accepted the award may file an application for referring the dispute for determination of the court inter alia as regards the amount of compensation. Then the state would have filed such an application, did not choose to, only the appellant gave because said provision, culminating in the pass of the judgment of the High Court. Thus, the award answer became attained finality. Then, my lord, kindly look at proposition of law. My learned friend relied upon paragraphs 26. 26. 26 in Gulab Chand. Totalan Party, the state of Bombay, the constitution may held that the judiciary also applicable to subsequent suits where the same issues between the same parties had been decided in earlier proceeding under Article 226 of the Constitution. It is tried that principal residue also appear in proceedings. 27, Bhanu Kumar Sansar, 28 also similar. I am not disputing this proposition. For that, my learned friend would also have to show that the NCLAT decided that I have to pay transfer fee. The issue there was, my lord, that I had asked for waiver, and because waiver was not given by NCLAT, I went up in appeal saying that I don't want to be part of the resolution plan. To that, my lord, COC and WBID say, no, you're not supposed to pay. No transfer fees. NCLAT did not go into all these issues. Say, sorry, the resolution plan is binding on. Like, my lord, I also can't say, my lord, the NCLT or NCLT, my lord, has decided on the issue. My learned friend also can't say. In fact, my lord, if he relies on NCLT judgment, Ghanshyam Mishra goes against him. Whatever I bid for, whatever the amount I've given into the resolution plan, there can be no additional expenses. My lord knows Ghanshyam Mishra. I, my lord, cited Ghanshyam Mishra, my lord, on the first occasion as well. SR Steel and Ghanshyam Mishra. But that's why I came and said, my lord, I took 3 points. 1 point you might reject. What about the other 2 points, which, my lord, there's no answer?
And there is a rejection order also by them. Did you make this claim before them?
Yes. But kindly come to, my lord, page, my lord, 6 July 2022, which is 431.
431, which volume?
My lord, volume 4. My lord, I showed, my lord, a reply at 424. (431), my lord, 6 July 2022 letter.
Yes.
My lord, in reply, my lord, to my letter of May 20th, 2022. And kindly come straight away, my lord. There is all, my lord, narration with regard to NCLT, but kindly see why they rejected. 433. It's not that, my lord, they're saying NCLT or NCLT has directed you to pay. In the middle paragraph, my lord, very important. It is repeated and reiterated that the sublease was created pursuant to terms and conditions of allotment made in favor of WBIDC by the government of West Bengal. Said lease dated 3 September 2009 provides the bar upon subleases being the cooperator herein from transferring its rights under the sublease dated 3rd September 2009. I've shown that clause, my lord, page 100, my lord, will recall. That WBIDC considers change in majority shareholding and directorship of sublease lessee as an event of transfer of lease, sublease, and the conditions of WBIDC regarding payment of transfer fee and payment of all outstanding dues become applicable. In this respect, clause 12 of the order dated 26 December 2012, which I have shown, issued by the government of West Bengal Land Reforms Department Land Policy, provides that the allotee is obligated to indicate upfront to the lessor any change in ownership structure of the allotee, and the lessor may cancel the allotment if it finds the change in ownership detriment to public interest. Pursuant of the order dated 26 December 2012, WDS has framed the terms and conditions of allotment of land module, and the same is applicable to all existing leasehold, including sublease dated 3rd September. Following condition also required to be complied with forthwith, which are mentioned here and below. Then, my lord, 434. After my lord quoting that, it is evident that the aforementioned clauses that in case of transfer that affects the ownership and control of the corporator, prior permission is required to be taken from WBIDC, and the transfer affecting the ownership and control of the corporator shall only be allowed after making payment of transfer fees applicable. It is denied that in terms of the Insolvency and Bankruptcy Code 2016 and relevant regulations, Ramswarup Industry Limited being the corporator herein shall remain as it is, and therefore shall continue to exist with all its rights it had prior to commencement of a corporate insolvency resolution process on all its assets, including its rights over demised land as alleged at all. Resolution plan itself contemplates change in shareholding of the sublessee corporator. Therefore, since the majority, now let's see, therefore, since the majority shareholding of the corporator will change pursuant to the resolution plan, it is imperative and or incumbent on the part of the resolution applicant to make payment of transfer fee of 6 crore 46 lakhs. In such circumstances, we hear. It is also not his case that NCLAT has directed you. He also says because there's a change in shareholding and because of the land policy, I have to pay.
That he has not submitted also. He has not said that there is any direction by the NCLT or NCLT.
Then, Mullah, if there's no direction, Mullah, that's the end of the matter.
He says it is an issue already considered. That is his
Mullah,
case.
I shouldn't give any reply to reply.
Mullah,
There is no.
Mullah, just
If your lordship kindly leaves the contents of my letter.
Mullah, I'll just
reply. I'm sorry.
I'm so sorry. I'll just finish in 1 minute. Mullah, I don't think, Mullah, we should. Mullah, if NCLT or NCLT has not decided the issue, then, Mullah, there is no principle of law which will, Mullah, prohibit or bar the court from looking into the legality of the demand. Either, my lord, that's why, my lord, he relied on res judicata. Res judicata means, my lord, this issue has been decided. If, my lord, his argument is not decided, then, my lord, it's all right.
Want to say something? Tomorrow we can keep.
We'll come back tomorrow.
So whatever.
Tomorrow with whatever day suits you.